recording. So there you go. So the recording started. Yeah. I don't know how many people are present
11
now. Yeah, so yeah, so still a little bit limited.
Yeah, really,
but let's maybe start.
Thank you for joining, guys. Thank you for being there with us today. Good to see you.
Yeah, so I'm also happy to see you. I was also very happy about the session last week and having some people on site and being able to work together on the licenses also with some who were participating online. So that was very nice. So thank you for those who actively participated. So today there's a little bit less expected participation, but of course, if you have questions, you can always say that. So I will, at particular moments, I will ask, are there any questions? But if you have questions in the meantime, we're with a relatively small group, so you can use this raise the hand function or just say, sorry, I have a question, and we can immediately tackle it. So you don't have to postpone it towards the end. But no exercises today, and actually a lot of cases to discuss with you. So can you see now that has the presentation shifted to the next slides where you see the kind of overview?
No.
No, it didn't shift. So maybe I should stop sharing and try it again just to be sure. We thought we wouldn't have any technical issues this time. There shouldn't be any technical issues actually, but otherwise we would go back to the previous approach where you would share the presentation, and because you have the presentation too. Let me try it once more. Because it is a little bit more convenient if I don't have to ask you all the time to change slides.
Yes.
So, but maybe I don't put it in the presentation mode. Maybe that would be helpful. So can you see the presentation again?
Yes, and now it's changing. So
now it's changing. Okay, so if it's not changing, so in the beginning I will say, okay, I'm now going to slide this, or so if you see that it's not moving, please let me know so that we don't get any delay there. But normally, Valerie, you have also uploaded the presentation already, so they can also see the uploaded.
Yes, and I will put it on the chat here, so they already have it directly.
Yeah.
Great.
Okay, excellent. So today I will start with the pharma sector, and so the next part will be with Miguel focusing more on standardization. Already during the first and the second session, there was quite some attention for standardization, but yeah, in fact, a lot of recent cases have been in that area, and this is really quite controversial. The same also for pharma. Also there you see that this interface between an IP and competition law is very important, but also quite complicated and raises particular questions. So this is why we think it's justified to have a whole session dedicated both to standardization and to the pharma sector, because there's quite some interesting special characteristics or things to think about with respect to the pharmaceutical sector. So if you want to have a kind of quick update, I can recommend you this short video, which is available on Spotify and which explains actually quite well some cases. It's now a little bit older, so there have been some recent developments, but I think it's still quite up to date. So if you're interested in just having some more materials, that could be quite helpful. So to start explaining a little bit more about the sector, and especially then also the role of IP law in that respect. And here you need to think especially of patents, but also know-how, because as we have been discussing this, the first and the second lecture, these are highly complementary. So, and also in the pharmaceutical sector. So the pharmaceutical sector is one of those sectors where IP protection is considered really important. And there's a lot of economic research by economists who have special expertise in patents, who have been also comparing different sectors, trying to see the need for IP protection. Because if we actually don't need it, and if there's other incentives available, which would be sufficient to convince people to innovate in a particular sector, then granting IP protection would not be justified. But so in the pharma sector, it's one of those sectors where economists have come to the conclusion, yes, in this sector, it is really justified to have patent protection, even when we see a quite fragmented landscape of patent protection. So why is that so? So why is it considered justified to have quite extensive IP protection in the pharmaceutical sector? It's especially because the investments in the pharmaceutical sector in comparison to other sectors are extremely high. So research and development here needs to deal with a very high failure rate, because this is not just about developing a new and innovative and improved product. No, the product also needs to be safe and effective. And you also need to show that it's effective to treat a particular disease. And so already that effectiveness is a major biological hurdle. And then also the safety is another big hurdle. So this means that the development is actually part of a very long life cycle of the product itself, but also the patent life cycle is quite complicated. So what you see, and I have explained in the first class, that with patents, what is really important is that you, if you have developed a new product, that you are quite quick in applying for IP protection. Because the patentability is determined on the basis of novelty and inventive step. And so how is novelty determined? It's in comparison to the prior art, a very important term. So what is the prior art? This is everything, all products that are already available, all knowledge that is already available related to that particular medicine in this case, or therapeutic in this case. So also conference presentations are part of that. Patent applications by others or by the same company, they're part of that prior art. So filing quickly is really important, and that's for all sectors. But what is particular for the pharma sector is that such early patent applications, so in a very early phase of development of the products, are a little bit more challenging, because the marketing of the product is often many, many years later. So as you still need to go through the different clinical trials and the different stages of the clinical trials, that can be many, many years between the original patent application and the ultimate marketing of the product. And so this is, a fact of life in the pharma sector, but which is also one of the reasons why there are some additional types of protection, such as what I already mentioned in the first and second class, these SPCs, these supplementary protection certificates, which can give you a few more years of protection. So in addition to the 20 years of patent protection, these SPCs can give a few more years of protection. And then in addition to the patent protection, you need to get marketing authorization before you can actually put your product on the market. And in order to get that authorization, you need to submit a lot of data, a lot of different documents. But in exchange, there's also rules on data exclusivity and also market exclusivity. So you have a whole package of quite strong IP rights. So not only the patents with the duration of 20 years, but so also some supplementary rights, such as the SPCs for a few more years. And you have the data and market exclusivity. And so what you often see is that the reach of the data and market exclusivity, which according to EU law, can be 8 plus 2 plus 1, and depending on the type of product. I will not go into the pharmaceutical regulation in big detail, but just that you know that often when the patents have expired, there may still be market exclusivity, market and data exclusivity. So that's a kind of additional tool that pharmaceutical companies would have, and that strengthen the position of the original patent owner, so of the originator company. So this is also important to know. So in the pharmaceutical sector and in competition law, there is this distinction between the originator companies, so the companies that originally developed the product, versus the generic companies. So also in my presentation, I will use that term consistently, the originator companies and the generic companies. The generics, that's of course a more common term, but with the originators, sometimes people are a little bit confused by that term. But so these are basically this is basically the company that first developed the product, and the product can then be improved by others, by competitors. But so after the expiration of the relevant patents, it will then be the generics that are willing to put the product on the market, often against a much lower price. And so another specificity of the pharmaceutical sector is the importance of blockbusters. So as in the whole research and development cycle, the failure rate is so high because of this additional requirement of effectiveness and safety. So what do pharmaceutical companies do in order to make up for those for that high failure rate? They will, the blockbusters, so the very well-selling products, are even more important, which means then that if those blockbuster medicines, if the patents are close to expiry, pharmaceutical companies often take relatively big risks in trying to extend patent protection. And so this may be through secondary patents. So this may be improvement patents or patents related to an improved dosage regime. So this is also something that I mentioned in the first class. Or it may be improvements of small aspects of the products related to the ingredients. Or also they sometimes use the strategy of filing divisionals. So here you would have one kind of parent patent, which is the most important, which relates to the compound, which relate to the product, perhaps also with some aspects of the process of the manufacturing of the medicine. But so these kind of parent patents, there are often kind of subtopics within a patent that can be distinguished from the core of the patent, and those will then be put in divisional applications. So this can only happen as long as the patent has not yet been granted, so as long as it's pending before a patent office. But so this strategy of divisionals is particularly interesting also in the pharma sector, but it is a normal strategy. So this is something which, according to European patent law and the patent office, it's perfectly legitimate. This fits within the normal rules of the patent system, this use of divisionals. But it makes the situation also much more complicated because you have several patents of one patent family filed in Europe. You remember that the patent rights are territorial rights. So you will have filed for protection in Europe, in the US, in China, and other relevant jurisdictions. So that is your patent family. And then within that family, particular parent patents, you may file divisional patent applications. So that makes what we call patent landscape quite complicated and quite fragmented. But as such, according to patent law in Europe and also in other jurisdictions, this is not violating patent law. This is in line with patent law, and that's important to remember, because you will see in the next step that the European Commission, in its pharmaceutical sector inquiry, has indicated that it believes that those kind of strategies may be problematic and potentially anti-competitive. But so those kind of strategies are common, and you see that especially with those blockbuster medicines, it's even more common. So the companies try to build a very strong patent portfolio, a very strong IP portfolio, a combination of various patents and know-how, and try to protect especially those blockbuster medicines in a very vigorous, and some people would say aggressive manner. But this can be explained also by the very, very high costs of investments and this high failure rates. And you will hear in the remainder of my presentation that I'm sometimes quite critical also of the conduct of pharmaceutical companies. But at the same time, I also really acknowledge, and I want to explain to you that the specificities of the sector also explain part of the behavior and a kind of protective, sometimes aggressive behavior and strategies and patenting strategies that are being adopted. So don't think that I'm overly critical. I don't think I'm that. I think I'm relatively realistic. Or you may disagree with me. But so I think it's really important that when you read cases from competition cases in the pharmaceutical sector, that you always have these specificities about how innovation is happening in this sector, that you take that into consideration. And then you may still come to the conclusion that something would be anti-competitive. But so this is really important. Another final issue there, which is really special for the pharma sector in comparison to other product markets, is that many diverse actors are involved. So it's not just a regular consumer, a regular customer that can freely decide on the products that he or she wants to buy and consume. No, the consumer is a patient, and often the decision is not made, it depends a little bit on the type of medicine, but in many cases, the decision is not made by the consumer. It's the doctor. Also, national insurance schemes are really important. And so it's the payers, the doctors, that really decide on the kind of products that are being consumed. And of course, that's reality also has an impact on price setting behavior. And it has an impact on the market definition, which here is relatively complicated. And so also in various cases in the pharmaceutical sector, in terms of market definition, what companies have been trying to say is, okay, the normal principles of market definition, they don't apply to the pharma sector because this sector is highly regulated. So that's an argument, and it's true. It is highly regulated because we want effective and safe medicines. And also there is in many countries price regulation. And it's not a free market where prices are determined by offer and demand, but the prices are often also set in a dialogue with ministries of health who want to push down, of course, the prices because this is a very heavy burden on the health budgets of the countries. And so there's a very heavy pressure on the prices. And so it's not a kind of independent pricing behavior by pharmaceutical companies, which you would have in many other sectors. So in that sense, it's really very, very different. And so that has been used as a kind of justification for saying, okay, in the pharma sector, we cannot use the same principles for determining the market. But in various cases, both the commission, but also the general court and the court of justice have said, no, okay, no, we don't really see it like that. The normal principles of market definition also apply here. And we may give special attention to those kind of characteristics and the importance of other actors, also considering that the consumer is not a normal consumer, and that there's others such as doctors and insurance schemes that have an influence in the products that are being bought and the prices that are being determined. So very, very important for the remainder of my presentation, but also if you prepare for the exam or if you are involved in a pharma case and reading some of those cases to keep that into consideration. And so on this slide, I'm now on slide 5. So tell me if you're not on slide 5, if you cannot see. Okay, thank you, Vivian, for confirming. It's always nice to see people nodding and smiling and frowning, maybe, if need be. So on this slide, you basically see that pharmaceutical life cycle, and you see all the different IP, right now. Well, basically, it's not a complete overview, but it's a kind of simplified overview of how patents are playing a role, how also patent exclusivity is playing a role, and then in that life cycle, what is the development of the price. So prices are really quite high, but then after the expiry of the patent, after the expiry also of the supplementary protection certificates, if they are applicable in that particular case, then the average product price will go down very, very quickly. And that is, of course, in the interest, again, of national authorities who, again, have this health budget, which is growing and growing, the more that also our populations are becoming older. So that's really a big challenge. So it's also understandable from health authorities that there is that push for market entry by generic producers because of that really quick price decrease as soon as generic companies are entering the market. At the same time, also the characteristics of the pharmaceutical sector explain why the originator companies really want to protect their especially the blockbuster medicines and try to extend also the patent expiry date if they can, for instance, through filing for secondary patents. So there's a tension there. There's a clear tension, and if you know the sector and understand this dynamic, it's understandable from both sides, both from the side of the originator pharmaceutical companies, also from health regulators and competition authorities, that they are worried about the very high prices. And sometimes if there are, for instance, settlement agreements, and we will talk a lot about the settlement agreements later on, if there are settlement agreements between the originator companies and the generic companies that would lead to a delay of the market entry by those generic producers. So that delay is a big concern to health authorities because they want the generic products to enter the market as quickly as possible. So if then the generic producer enters into an agreement with the originator company to say, okay, yeah, if you pay me, then I will enter the market later, because so how does such a procedure often happen? So the originator company observes that a generic producer is preparing for market entry, is applying also for marketing authorization, because not only the originator company needs to get a marketing authorization, the same applies also for generic producers. They also need to show that their product is effective and safe. And so when they're making those preparations, often the originator company will observe that and would start an infringement action against the generic producer, saying, okay, with these activities, the manufacturing that you're doing, you're infringing on my rights, and will ask for an injunction. And then there's of course a big risk for the originator company that the judge would say, okay, very nice, this procedure, but I think that the patents are actually invalid, the patents that you're invoking. So that's a big risk, especially if those patents relate to a blockbuster company. So what would then happen is that there's a big interest on the side of the originator company to settle and not pursue the litigation further because of that really high risk in case patents would be invalid. Because often they may be very certain about the relevance of their product and the strength of their patents, but it doesn't mean a judge would agree with that. So even though there is a presumption of patent validity, in many cases, judges may come to a different solution. So those type of settlement agreements between originator companies and generic producers are a big concern for health regulators, because they want the generic products not to be delayed and to enter the market as quickly as possible. But at the same time, there are those agreements. And so the question is, if there is such a delayed entry, is that then also anti-competitive or not? Or is that then that settlement agreement, would that be anti-competitive or not? So that has been very much on the agenda of the European Commission and also of national competition authorities. But we will come back to that, and I will give you many more slides related to the settlement agreements. But already here, I wanted to talk briefly about it, to show you this dynamic between the originator companies and the generic companies with this slide, which shows you the life cycle, the pharmaceutical life cycle, and how the two are interrelated, and how this very complex landscape of patent rights and SPCs and market and data exclusivity makes that dynamic much more complicated than other sectors. And so this next slide related to the demand and supply in pharmaceutical markets show you how indeed doctors are involved, patients are involved, and patients of course have an influence to a certain extent, but it's really much more on the side of the pharmacists, on the side of the health insurers, and on the side of the doctors in terms of determining which product is being used to treat a particular disease. And so this highly regulated sector, so this slide number 7 really relates to the very complex regulatory environment. Again, with a very simplified overview. But so where the marketing authorization, so this is happening not only at the European level with the European Medicines Agency, which we have heard about a lot within the context of COVID as a major determining actor in terms of the grant of the marketing authorization. But there next to the EMA, there's also a very important, crucial role for national authorities in granting the national marketing authorization. So part of the process is by the European Medicines Agencies, but there's also still a role for national authorities. Again, I will not go into the details of that regulatory environment, but I want to emphasize that it's not just at the European level, but that there's an interaction with national authorities as well. Looking at all kinds of data, the outcomes of pharmacological and toxicological tests through the different stages of the clinical trials before actually the marketing authorization is granted. Then on the other side, this pricing and reimbursement decisions, which are not happening at the European level. So there is some coordination and some exchange of information in terms of pricing and reimbursement at the EU level, but that's very limited. So the EU has very limited competences when it comes to pricing and reimbursement. And this is primarily done by the national authorities. Again, this is a big complicating factor for this sector. And so this is also something that you see reflected in the AstraZeneca case that already was touched upon briefly by Miguel in an earlier class, but which also very well shows the complexity of the role of national authorities in this pricing and reimbursement, and also the many gaps in the regulatory environment that leaves space to pharmaceutical companies to give information that may have an impact on the decisions by national authorities, things that may delay the entry by generic companies as well. So again, to show you that this regulatory environment also creates space for companies, and we often have a lot of experts that work for them to find those gaps. And so the question then is, if a company uses the gaps in national regulation and uses those gaps to delay entry by generic products, Is that then misuse of such national procedures? Is it even anti-competitive behavior? Or is it a problem in the national regulatory environment? So, and those questions, people would give different answers to those questions. Is it, so the first question, is it abuse of misuse of a procedure? If you would say it is, and it's not a problem in the national regulatory environment, then would such behavior also be considered anti-competitive? And basically what the Commission has clarified, and also the General Courts and the Court of Justice have indicated in the AstraZeneca case, is that in specific circumstances, indeed, using the space in national regulatory authorities could be considered as a misuse, as an abuse of a dominant position. And so this is also why that case is considered quite controversial. So a lot of people would say already, first, is that a task for the competition authorities to look at that? Or is it more something which is relevant for from a regulatory perspective? And where they would say, no, this type of behavior does not belong as a decision-making point for competition authorities. Okay, so where am I now? I have been, yeah, so here. So I'm going to the next slides, number 8. So the risk of free riding, if you want to use that word, by non-original pharmaceutical companies is quite significant, especially if you think of the current, still mostly common traditional medicines. So when you think of medicines which are more of the biotech medicines, which are much more complicated and that are less just based on a kind of synthetic manufacturing process, but require much more input also from a biotechnological perspective. So there also we have a kind of different regulatory approach for those more advanced medicines, which are then referred to as biosimilars. So they are not generics, they are not exactly the same product, because it's basically impossible to have exact copies of such products. And this is why they are called similar rather than really a generic. And so here some people say, yeah, maybe the free riding, which is so common with current medicines, may be less prevalent when you're looking at biosimilars. But also there is some discussion, because a lot of people say, okay, the more the technology is developing, also creating biosimilars will become easier and easier over time. But so that I find difficult to actually make that assessment. So there seems to be a kind of a different idea about that. Another aspect is that a lot of those medicines are also more personalized medicines and are also aligned with our genetic disposition. So before a doctor would determine what kind of medicine or treatment is most appropriate for you, there would be genetic tests that is carried out, and on the basis of those results, it would be decided which medicine is most appropriate for you. And so that's why people often use the term personalized medicine. So it's really the combination of genetic diagnostics with a particular medicine. And also there, people say, yeah, there will be a shift. And so maybe really this high free riding risk should be reconsidered with an increase in this more personalized perspective on medicine. But so this is something that is happening now, which will become more and more prevalent the coming years. But it may have an impact, or it should have an impact, perhaps, in my view, also in terms of the market definition, because if products are really personalized, that is then suddenly a very different situation. But as I will also mention later, in the pharmaceutical sector, the market definition is often defined in a rather narrow manner, looking at very specific classes of of medicines. It depends, again, a little bit on the type of medicines and whether there are many alternatives available. But so in general, you could say that often the markets are defined in a quite narrow manner. With personalized medicine, the first thing you might think is that it should be even narrower, but is that actually possible? At least it requires a reconsideration and thinking about definition of markets, the more that the pharmaceuticals or personalized medicine becomes more and more common in this sector. It raises new questions and new challenges there. Yeah, so I think I have covered this sufficiently. So this next slide then emphasizes also how innovation is happening in this sector. And so in many cases, you might really speak of radical innovation, especially if a new medicine is being developed, if there's no alternative treatments. Of course, this is radical innovation. But also there's a lot of improvements going on, improvements to the benefit of the patients, maybe because there would be less side effects to particular medical treatments, or because the dosage is much easier, or maybe something that would require an injection when a product is just developed and that could later be taken through tablets. May have really major advantages for a patient, but could still be regarded sometimes as a more incremental innovation in terms of looking at it from a more objective perspective. But for patients, this can have very, very high value. So also the secondary patents that would relate to such improvements in terms of the dosage or in terms of decreasing the side effects could really add enormously to the value of a particular product. And so this then is an important question when you think about prices and what is an appropriate price, or also under Article 102, the abuse of a dominant position, excessive pricing. So excessive pricing is becoming a more and more important topic in the pharmaceutical sector. I was just looking at the time and seeing that the time is passing so quickly. So excessive pricing, really, really important. The European Commission is looking at it. And also national competition authorities are looking at it. Again, because of this pressure on the health budget. And because of these personalized medicines and more complicated medicines also, for instance, to treat various types of cancer. So the costs are going up. And so there's a big concern about the prices in the pharmaceutical sector. And so also excessive pricing as an anti-competitive conduct, as possibly abuse of a dominant position, is getting a lot of attention in that respect. But then the question is, how do you determine the price? How do you determine whether something is excessive, whether something is an unfair price, which, as Miguel has explained last week, which is required by the United Brands test. And so applying that very common test for determining what is excessive is already difficult in normal sectors. So the United Brands case was about bananas. And you can imagine that the complexity of bananas in comparison to pharmaceutical products, there's a significant difference there. And so thinking about the value of a product, you need to think, okay, what kind of value is that? And how will you assess this? Which methods do you use for assessing the costs of producing, for assessing the marginal costs? And so that evaluation is especially complicated in the pharmaceutical sector. So this kind of very simplistic way of looking at innovation as a kind of incremental innovation when it's about changing the dosage or decreasing side effects, if you look at it from a patient perspective, which some scholars suggest that some competition authorities look into that as well, but also others really push back on that, because it would probably mean that the value would be set at a higher level, which means that competition authorities would not as easily be able to say that something is excessive. but we will come back to that in a bit. But so here, I already raised this because of these different types of innovation and an often rather simplistic view on what is incremental, depending on the perspective that you're taking. And that perspective may be very different if you think of it as a patient. Also, other specificities is the volatility of the markets. And so also a lot of the originator companies are also increasingly producing generic products. So you cannot just say, okay, this company is always an originator, and those companies are the generics. And then some people say, yeah, the generics, they're the good guys, but they also just want to make money. And so it's not about good or bad. It's not about originator or generic producer. That may really depend on the product. And an originator company may, for some other products, also be a generic manufacturer, which again complicates an analysis of the markets. And so there's the interface also between pharmaceutical companies, who more and more also buy small spin-off companies, small biotech companies. There's also increasingly collaborations with diagnostic companies. And so increasingly also with what you saw on the previous slide, we also see more and more open innovation and collaborations with all kinds of actors, with universities, with small and medium-sized biotech companies, also sometimes with competitors. So a lot of open innovation, where in the past, let's say the last century, the pharmaceutical sector was seen as a much more closed sector, much more closed innovation. But because of this increased collaboration, and that is necessary because of the need for more and more complex knowledge and more knowledge transfer between pharma and biotech, pharma and diagnostics. So those collaborations are really essential also for facilitating the development of personalized medicine, but again, are an additional complication. And so the question then sometimes is certain strategies that are very common from a patent perspective that are also used in other sectors, which are compatible and do not violate patent law. In the pharmaceutical sector, the European Commission, but also national competition authorities are considering, okay, because of this very special, highly regulated markets, is maybe the responsibility of those originator companies, is there a kind of special responsibility, especially if you're thinking of an abuse of a dominant position? And is certain behavior where people would say, okay, this is a little bit in the gray area. Maybe it is tricky, but is it really anti-competitive? And so this is why in this sector, you have a lot of discussion whether certain questions are really questions of competition law, or questions of patent law, or questions of health and pharma regulation. And then a sort of follow-up question to that is, do competition authorities always have the required expertise to make a very advanced market definition, which is very complicated here? And what I think is good is that more and more also competition authorities have been learning and exchanging with patent offices and also with health regulators to try to understand the sector better. And I think that that's a really very, very important development. But so there are a lot of special issues that come up in pharmaceutical cases that you see less prominent in other sectors and that require special expertise. And so this is then also something that you see very clearly in the pharmaceutical sector inquiry, which happened basically in the first decade of this century, leading to a first provisional report in 2008 and a final report in 2009, where the European Commission was doing an inquiry to understand better what were the reasons for the delays in the late entry of generic medicines. Because they were observing a decline in innovation, there were less and less new medicines that were entering the market. And so they were looking at company behavior by 43 originator companies and 27 generic companies, looking at a very specific sample of substances. And so hopefully you know that inquiries are not showing that there's necessarily a violation of competition law, but it's really an assessment of the market, and in this case, the pharmaceutical sector. So this was not a kind of individual case, but a better understanding of the relevant context and a factual basis, which could then later lead to individual investigations, which also happened, as you will also see in my presentation. And so there were inspections, there were a lot of requests for information. So lawyers working in pharma and competition law were flooded with all kinds of questions and follow-up questions. There was also a stakeholder consultation of patient organizations, insurance companies, hospitals, pharmacists, also some interaction with European and national patent offices, national competition authorities, health authorities. So really a reflection of the complexity of the markets that I have explained to you before. And then there was this preliminary report of 2008, which was highly criticized because of the practices that were considered as potentially anti-competitive. The final report was still heavily criticized, but it was in terms of the grounding of that report, I think a lot of people saw a major improvement. And so what do you see in that sector inquiry? The analysis by the European Commission showed that there was a kind of delay of over 7 months generic entry after loss of the patent exclusivity. And according to the Commission, that would have led to a loss of about 3 billion euros due to that late entry. Of course, this is a static analysis, so it's not, it was up to them that they made that analysis for that particular sample of substances that they were looking at. And so the Commission then also pointed to particular strategies, such as these primary and secondary patents that I have discussed quite a bit in the first class, but also at the introduction of today's class. Which would then lead to kind of patent clusters, complicated, fragmented patent landscapes, where you would have a set of many, many different patents leading to some kind of cluster, sometimes also referred to as a thicket of patents. Also, the Commission was concerned about weak patents. And so the term weak patents, you hear it more by non-IP experts. It's a kind of way to indicate that there's a high likelihood that those patents would be considered invalid if they would be challenged. And so there would be a high risk that they would be considered either excluded from patentability. I've given you some examples of particular patents, especially also, for instance, biological processes, or also inventions of which the commercial exploitation would be considered against public order and morality. There are those exclusions in patent law. But even more importantly, inventions that would be considered not novel or not inventive, they would all be possibly invalidated either in an opposition procedure before the patent office or in litigation, for instance, if there would be an infringement procedure. But the issue is that often it's very difficult to assess whether there is a high likelihood of invalidity. So in patent law, once patents are granted, there is the presumption of validity. And so the patents are presumed to be valid unless an opposition division before a patent office or a court would say otherwise. And so this risk that it is invalidated is highly uncertain, and also depends on the side you are. The patent attorney who has written the patent will often be convinced that it's that it will be a good application, unless it's a kind of strategic patent application, but so in most cases, it's rather competitors or generic producers that would think that the risk of invalidation is high, and the originator companies not. But the originator companies have a lot to lose, especially again if it's for a blockbuster medicine. So even when the patents are considered very strong patents by the originator company, invalidation by, for instance, a judge that doesn't really understand the invention so well is a really high risk. So the term weak patents is not an easy term and highly disputed, especially amongst patent experts. But it's used by the Commission from in its sector inquiry, and also sometimes used in cases as a kind of argument to dispute the strength of the patent. And then also the Commission was very worried about these divisional patent applications that I mentioned before, which are also a quite common strategy. If you don't like it, if you think that this shows a kind of misuse of the patent procedure, then maybe there's a problem with the patent procedure, the fact that you can apply for divisional applications. But the Commission was looking at it more as a potential anti-competitive conduct. And it was also referring to defensive patenting as a kind of toolbox, a kind of strategy that is being used by originator companies to delay the generic entry. Also, it was concerned about the quite high number of patent litigation cases, also oppositions and appeals, both at the European and national level. But also Miguel has showed you last week that litigation, it's a right. Access to court is a right. So litigation from a competition law perspective, generally, it's not very easy to show that there would be some kind of vexatious litigation. And the same is probably the case also for patent litigation, also related to such secondary patents. But the Commission was saying, okay, we see a quite high success rate of generic companies in challenging granted patents. And for us, that is a point of attention. They were also quite concerned about these patent settlements and other agreements between originator companies and generic producers, which would lead to a delay of entry by those generic producers. Also, all kinds of life cycle strategies in terms of the marketing strategies that were being used, where, for instance, pharmaceutical companies for which the product was very close to market entry, they would start additional marketing campaigns promoting their own product and sometimes giving an impression to health professionals that maybe the product, the generic product, would be less safe. So that is a kind of marketing strategy that also the Commission was quite worried about, because it would lead to a lower interest of patients and doctors, health professionals in those generic products. So if there is some doubts about the safety of a generic medicine, of course, the patients would not be very eager to take such a medicine, which could be considered less safe than the originator product. So according to some people, that was a kind of such marketing behavior could be seen as a kind of lock-in, where even when patents would have expired and generic products would be available, that because of the marketing strategies aimed at health professionals, patients would still be more inclined, and doctors as well, to go for the originator product. So this was presented as a kind of toolbox of strategies which were considered concerning, not already anti-competitive, but potentially anti-competitive in an individual investigation. And so the Commission did then emphasize sort of different perspectives in its conclusions. So a kind of competition perspective where it was saying, okay, based on what we have found in our inquiry, we think there should be an intensification of the competition law scrutiny by the Commission, but also by national competition authorities. And so there's also many national cases, as you will see in the slides a little bit more towards the end. And then, but at the same time, it was also acknowledging, especially also in the final version of 2009 of the report, that also there were some gaps in the regulatory system, and that it was happy that there will be some upcoming changes in the European patent system, also creating a more unified patent litigation system. So I hope that you remember from our first session that there is this unitary patent package, which was adopted in 2012, which did not yet enter into force, still not. So the Commission was already waiting for it with its 2009 report. It's not yet entered into force, but will likely enter into force either later this year or in 2023. And so there's a lot of hopes that this would lead to a more unified litigation system. But if you would look at the details of the new system with the Unified Patent Court, it's still very complicated. And there is still a risk of different decisions by different courts. I will not go into the specificities of the system, but just that you know that the Commission was putting quite high hopes on the improvements to the European patent system that can be achieved through the unitary patent and the Unified Patent Court, but also that improved system, that new system under the patent package also still has some complications and challenges. We don't have the time to go into that. I could spend the whole semester just talking about the unitary patent, and I will not do so, but just that you're aware of that. Then also the European Commission expressed some comfort in the fact that the European Patent Office also has some projects trying to raise the bar to ensure that patents that are granted are really novel and inventive. And so a kind of a strengthened assessment of patents. And the EPO is very concerned about the quality of its patents. And of course, is not interested in granting, again, weak patents, even though it's not always so clear. It depends on your perspective, whether something is a strong or a weak patent. But the EPO is focusing on quality and always concerned about that. And so the Commission also got some relief out of that. But still, as we will see, is also still critical about a lot of the patents that are being granted. Then also streamlining the marketing authorization processes at the European level and the national level was a priority for the Commission. But of course, this is DG competition. So DG competition cannot do much about it, but it was emphasizing that that is part of the sector, of the context, which will also, of course, influence decisions in investigations in individual cases related to the conduct of Lundbeck, of AstraZeneca, of Teva, and all those cases that we have seen more recently. And also a need to improve the pricing and reimbursement system. So in the pharmaceutical sector inquiry reports, the Commission acknowledges all those challenges, acknowledges that it's not just a competition issue, that there's a lot of regulatory aspects which are also complicated and that can that have an influence on the context of the behavior by companies. But it still lists this toolbox of strategies that companies are using. And so there was a lot of criticism, and now I'm on slide 18. I hope that you're still with me on the same slide. So concerns of about the impact on innovation because of the report of the Commission, also concerns about problems in the regulatory framework, and also criticism in terms of the interface between patent and competition law, and what is the task of a competition authority and what is the task of a regulator or a patent office in terms of trying to improve the regulatory context. And or maybe at this point in time, I first want to check with you whether there are any questions, either more about the special characteristics of the sector, or about the sector inquiry? No, I see Eve indicating no. I see no hands and I hear no voices. So I guess I can continue then for now. So I will continue in this mode and not in the presentation modes to ensure that we don't get stuck on the presentation. Even though, of course, it's maybe not, it doesn't look as smooth as putting it in the presentation mode, but let's just continue like this. And so one of the priorities of the Commission in the pharmaceutical sector inquiry were these settlements, these agreements between originator companies on the one hand, so the company that develop, that do the research and development and that come up with new products and treatments on the one hand, originator companies, and on the other hand, the generic producers. And such agreements would lead to serious delays in market entry by the generic products. And so what are those settlements? So those are agreements between originators and generic producers in the context of either patent litigation or an opposition procedure before a patent office, where then those companies say, okay, there is, we both have interests in settling this because, of course, litigation, it takes a lot of time, it's very expensive, and often there is uncertainty about what the outcome will be. And especially this big uncertainty is a big risk for the originator companies. Again, especially if this is about a blockbuster medicine and they're really dependent on trying to get a reward of their investments and also to sort of compensate for the many failures of medicines which couldn't ultimately be proven to be safe and effective. So the risks on the side of the originator companies is significant. The risk of litigation, the risk of such opposition procedures, that there would be an invalidation, even when they believe that their patents are valid, and they don't see immediately why they wouldn't be considered novel and inventive, the risk is still higher than for a generic producer who would simply wait a few years before the product is put on the market. So what you then see in, for instance, also the technology transfer guidelines. So last week we looked at the technology transfer block exemption regulation, and we looked at some rather simple licenses and also these pool licenses, this Philips DVD pool license to check the compliance with the block exemption regulation and also the technology transfer guidelines. So also in terms of patent settlement agreements, there is a special section in the technology transfer guidelines dealing with that. And so in those guidelines, you see that the Commission is also acknowledging that there are legitimate interests in settling because of the costs and the time-consuming nature. And it's not only in the interest of the companies, of the originator company and the generic company, but also in terms of the court system, because litigation takes a lot of time, efforts. So if a conflict can be settled, it's also cheaper in that respect from a societal perspective. And so in general, settlement agreements are a generally accepted, legitimate way of ending private litigation. So that is acknowledged. That is the starting point. So many settlement agreements will be fine. Also when it is between an originator company and a generic company. But so what the Commission then tries to do is identify the settlement agreements that could be problematic. So some patent settlements are problematic according to the Commission and also according to these guidelines. And those agreements are then often sort of categorized as reverse payments or pay for delay agreement. So a settlement agreement where the originator company is paying the generic company to delay market entry by the generic products. And so that delay is an important determinant element of the analysis. Also, when there is a value transfer, so when there is money flowing from the originator company to the generic company, then the Commission says, yeah, if the originator company is paying, then probably he has some doubts about the strength of the patent. I have put some side remarks whether that is a valid assumption or not, but this is the assumption by the Commission. If there's a value transfer, then maybe there's something going on, and we should pay attention to those settlement agreements where there's a value transfer. Another type of settlements that are considered potentially problematic from a competition law perspective are settlements that would contain restrictions beyond the exclusionary zone of the patent. And so here, again, I referred to last week where we talked about the material scope and the geographical scope and temporal scope of licenses. Of course, you also have that same material scope and geographical scope and limited temporary scope of the patents themselves. So when a settlement agreement contains restrictions in that regard, that is another point of attention then for the Commission to say, those kind of settlement agreements, we should take a closer look. And also settlements where the patent owner knows that the patentability criteria are not met. So this is what the Commission identifies as another determinant, as a kind of indicator. But I have already explained to you that it's not always so easy to know whether an invention meets the patentability criteria. There may be different views on this. It may also depend on the stage of development of a particular market, of a particular product. But so the Commission sees that as a kind of indicator that a settlement could potentially be problematic, even though this may be quite difficult to assess whether there is a risk that those patentability criteria are not met. And so again, here a kind of image to show you the kind of scenarios for a normal competitive situation where after the expiry of the patent, price will go down with the generic entry. So when there would be such a pay for delay settlement agreement, that moment of entry is much later, 7 years or less, sometimes even just a few months. But a few months may already be very valuable if it's about a blockbuster product. So this is very important to see that already a few months may be very, very important for an originator company to recoup investments, and the generic company doesn't lose so much, especially if it also gets paid in exchange for entering into the settlement agreement. But so that delay is a big concern for the Commission. And so what you then see is that the Commission sort of sets up criteria to assess the settlement agreements, looking at particular limitations that you find in such agreements. So if there is a non-challenge clause, a non-compete clause, and these we have also discussed last week within the context of licensing, or particular distributor agreements which would entail significant value transfers, that would really be, again, an indicator for the Commission to pay close attention to such a settlement agreement. And as I said, if there is a value transfer, this is, again, an indicator for the Commission to look closely at that settlement agreement. And so then the Commission categorizes, so all settlement agreements that do not restrict the generic's ability to market its own products, all those will generally be fine, because then you would have competition, because you have both the originator and the generic products. But an agreement that limit generic entry where there is no value transfer will also, in most cases, be fine, unless indeed there would be a restriction in terms of the material scope, the geographical scope, or if there would be some kind of concern about the validity of the patent. But settlements with value transfer would always lead to serious antitrust scrutiny. But the Commission also says it doesn't mean that all settlements that involve a value transfer would violate competition law. No, not automatically. It would just require a very close assessment by the Commission. And so it then has developed this scheme. So basically it's the category B2 So those are the settlement agreements that limit generic entry and that contain a value transfer. Those are the settlement agreements that the Commission is quite worried about. And so interestingly, what did the Commission do then? Is that in the following years, so after the pharmaceutical sector inquiry and after this new section in the technology transfer guidelines and this clarification of the settlement agreements that could be considered potentially anti-competitive, the Commission has been monitoring such settlement agreements, and it has been collecting a lot of information on such settlement agreements. So here you see an image that relates to 2016, so January 2016 until December 2016, that shows up till then the increase in the number of patent settlements. And you see that around 2012, there were really quite many. And that there has been also a growth starting from the years 2000 in such patent settlements. So this graph doesn't show that there's a lot of competition violations. No, it just shows that there was an increase in settlement agreements. And some of them may be potentially considered anti-competitive. What you also see here is that there's this sort of dark blue part, which relates to settlements in Portugal. Because in Portugal, there's actually a special procedure to stimulate companies to enter into such patent settlement agreements because of the societal benefits of solving disputes out of court. And so you see a lot of such cases in Portugal, not necessarily problematic from a competition law perspective, but this is why you see a kind of special category for Portugal, which you will also recognize on this next slide, where you see in Portugal, in comparison to all the different member states, many more settlement agreements than in all the other countries, even though, of course, Portugal is not one of the biggest countries in the European Union. So if you compare that, for instance, to Germany, the number of patent settlements is significantly lower than in Portugal. But so this is because of that special procedure in national Portuguese law. So don't worry too much about that, but I just wanted to explain to you why there is that really high number in Portugal, because otherwise you might be quite surprised by that much higher block for Portugal than for the other countries. And so if you look also at the following years, you see that the number of settlement agreements after 2016 has been slowly decreasing, where here the average was, let's say, around between 30 and 10 for most of the countries. If you look at the later years, you see that we go more between 20 and 10 or even below 10. So whereas for some countries, there was a growth in patent settlement agreements, if you look at it in a more general manner, after those in those later years, there has also been a slight decrease in the number of cases. And then, of course, what we are particularly interested in this is this category B2. So the settlement agreements where there is a limitation of generic entry and a value transfer. And so that number of settlement agreements, there the Commission would say, oh yeah, let's take a closer look at those settlement agreements. And if you then look at the number, you see that that category is relatively small. Yeah? So it's a small group of agreements that would potentially be anti-competitive. And so this is a graph from the report of 2012. And also, if you look at the later years, you see that this is really a relatively small percentage. So here it was 6, it goes a little bit up in terms of the total number of settlement agreements. Here we're at 10% and 11% in 2016, but it's still a small category if you compare it to the other agreements. So that is really important also to realize. So it's not that all settlement agreements that are that parties agree to are suddenly problematic, since the Commission has been taking a closer look at those agreements. So there's quite some. There has been an increase and then a slight decrease in the later years of this last decade, but the number is relatively small. Then if you also look at the type of value transfer, because of course, if value transfer is an important indicator for the Commission, then we also need to know what kind of value transfer would that be. And so the Commission looks at it in a quite broad manner. So also, if there is a value transfer more through a kind of distribution agreement or a kind of license agreement, that would also be included in this group of B2 patent settlements. But the biggest concern is when there is a value transfer without such additional agreements, because that shows that there is nothing else happening in terms of creating more competition, in terms of distributing the product and involving the generic manufacturing also in a different way in this particular complicated market. So there was the pharmaceutical sector inquiry, 2008, 2009 were the reports, where the Commission listed different types of conducts and identified a kind of toolbox which would be potentially anti-competitive according to the Commission. And then patent settlements were one category of conduct that it wanted to look at more closely. Then the following years, they did this monitoring exercise, and this monitoring exercise shows that the number of patent settlement agreements where there is a value transfer is relatively limited, but the Commission was still really following up on it, but because it was still concerned about those agreements. And so you also see several decisions by the Commission in the following years. So the Lundbeck case, there was also the Servier case. And so also some of those cases also went to the General Court and also to the Court of Justice. So this was sort of the timeline from the sector inquiry also to individual investigations and some cases also before the court the last couple of years. I will come to those court cases after we have had a short break. But before we go to that break, I want to also mention a more recent report. So after this monitoring, which the Commission was doing yearly, then there was another quite interesting report in 2009, where the Commission was giving an overview of enforcement, so public enforcement by the Commission, by national competition authorities in the pharmaceutical sector. And so also there you get a really nice overview of the type of conduct that the Commission is looking at. And this deals both with 101 and 102 cases and investigations. And in some cases also the behavior can be classified both under Article 101 and 102. For instance, when an originator company is engaging in many different agreements with generic producers, and that it's a kind of strategy. And that strategy as such, so the agreements can be assessed under Article 101, but the strategy adopted by the originator company would then also be assessed under Article 102 as a potentially abusive abuse of the dominant position. So then both articles or an assessment of both articles could be relevant when there is kind of a whole cluster of agreements that in itself could be anti-competitive, and on top of that there could also be potentially an abuse of the dominant position. And so what do you see is a lot of investigation. So in this graph that you have here, so the red part is investigations but no interventions, so quite a large number, and then also some intervention decisions and also still some cases ongoing. So which authorities are actually most active in the pharma sector in terms of the enforcement. So you see the big blue chunk, it's especially the European Commission that is adopting or that is doing a lot of the investigations and also leading to some concrete decisions. But also a number of specific competition authorities are especially very active. And you see that the United Kingdom and also Italy have been quite active in the pharmaceutical sector. And so in my presentation, I will refer a few times also to national cases, but I'm not exhaustive, not at the European level. There, I try to give you some additional names apart from the cases that I discussed today. But by far, I'm not exhaustive when it comes to national competition authorities, decisions or investigations, but especially also the UK competition authority has issued some also really very well argued decisions and very readable decisions. So if you're, for instance, if you're like for your practice, you want to know more also on excessive pricing in the pharmaceutical sector, I can definitely also recommend you to look at the cases of the UK Competition Authority, because I find them quite clear, very long, like many of the competition decisions, but very easy to read. And also the commission and also the UK Competition Authority is applying the United Grants test also after Brexit. And also explaining very well on the basis of case law of the European Commission, referring to case law of the European Commission, and referring to case law of UK courts, clarifying very well the different steps in the analysis, also the market definition, and also the analysis of the excessive nature of the price and the potentially unfair nature of the price. So if you want to know more about this, I can definitely recommend you to take a look at those cases also of the National Competition Authority, especially for excessive pricing, because at the European level, we have only one commitment decision, which you will see also later in my slides. There's a Aspen commitment decision. Yeah, as it is a commitment decision, it's of course a little bit different from a final investigation decision. So in that sense, also the decisions by national competition authorities are quite good. If you want to look at Italy, so I think the most important cases of the Italian competition authority are also translated in English. So if you would want to make a comparison, those are also really worthwhile to look at. So now we know which competition authorities are quite active in the pharmaceutical sector. And so this relates both to 101 and 102, this graph, but just indicates which enforcers are taking up those cases. And here you see that actually a large number of those cases relates to abuse of a dominant position. So this is the purple figure that you see on this graph. But also some cases may relate to both. So what kind of conduct is then the subject of a lot of those cases that are assessed in this pharma report of 2019? Patent settlements, I've already mentioned that. So not only at the European level, also at the national level. Misuse of the regulatory framework. I've already mentioned the AstraZeneca case, and we will come back to that after the break. Also disparagement practices. So the marketing strategies that I explained to you before. So the marketing strategies where an originator company will give information to health professionals about the alleged unsafety of generic products. So this is also relatively common practice that is receiving attention of competition authorities at the European level and the national level. I've mentioned already excessive pricing. So the United Grants test that is being applied at the European level and national cases too. Coordination between companies in trying to achieve higher prices. So this is sort of playing games with the national authorities that set prices and that decide on reimbursement. And also restrictions on parallel trade are also another type of conduct that is dealt with by authorities. So I think this is maybe a good moment before we go to the last part of the presentation to take maybe a 10-minute break. And then after, so we will start again at 3:08. And then we will discuss the more concrete cases. So now you have the groundwork, the basis, the principles, and the conduct which, according to the Commission, require special attention and are also getting special attention both at the European and national level. And then after the break, we will look more specifically at a few of those cases. But we will need to go relatively quick because the second half of today's class, you will move from pharma to standardization and telecom and mobile phones. So we will go through this relatively quickly, but you will have a summary. And you can, of course, definitely also look up yourself summaries of the Commission on those cases. For instance, if you want to read some more, but not necessarily the whole decisions, I can also recommend you to look at the competition law blog. They have pretty good analysis of many decisions and cases of the Court of Justice. So to get a better grasp in deciding whether you want to be courageous and read the whole decision, and that may also help you deciding on that. So that's a good additional source for summaries and a better understanding of those cases. Okay, so let's take the break now and start again at 3:08. So take a nice coffee and see you in a bit.
Yeah, thank you.
So I would like to suggest to continue. But again, before doing so, I would like to check with you whether there are any questions at this point in time. Not immediately. Okay. So then I will share the screen. And yeah, so this looks a little bit weird because the presentation mode was not working so well because it was blocking a little bit. So normally there you would see this step by step with the different text boxes. But so the Lundbeck case is a really important case in terms of the patent settlement. So this related to a blockbuster antidepressant, a really important flagship product for Lundbeck. And as I indicated before, those blockbuster medicines are often regarded by pharmaceutical companies as a important way to recoup their investments, also on other R&D projects which had failed either for reasons of effectiveness of safety in the whole process of the clinical trials. And so for this blockbuster, also Lundbeck had engaged in different strategies to try to extend the life of the patent. So the compound patent, so really the core product patent, was due to expire around 2000. Lundbeck was then in a very final stage of the life cycle of this compound patent. It was trying to apply for other patents to extend the term of protection through those other patents. And so remember this distinction that I made between the sort of radical innovation and more follow-up innovation. And so often process patents are used in that way. Some people then qualify those as a secondary, qualify those as secondary patents or less relevant or more incremental innovation. But in practice, those kind of process patents can actually also be quite important and could reflect important innovation. And so what did Lundbeck do? So it settled with 4 different generic companies and paid a significant amount of money. So there was a value transfer involved in this set of settlement agreements with different companies. So what is also quite important in this case is the information that the Commission collected through its inspections on site. And it refers a lot to different types of internal documents. Also in its press release, it relates to some internal documents of Lundbeck where it was referring to a club that was being formed and a pile of money that was shared with all the different generic companies. And so also according to the Commission, that was not really evidence that this type of behavior would not be anti-competitive. And so also it was, the Commission was arguing that from those internal documents, it also could be derived that Lundbeck had doubts regarding the validity of the patent. And some kind of probability that the patent would be invalidated at 50 to 60%. So that was based on information that the Commission had collected. And that created, quite some concerns and attention, ultimately then leading also all up to procedure to at the court. And so what you could see, what you could read in some of those documents is a kind of bias of the Commission against process patents. But as I also did before the break, again, I emphasize that according to patent law, there is no distinction as such between product and process patents. These are equally relevant patents. It's not that one would be necessarily better or worse than the other. There are no categories in that respect. They may be more valuable. It may be the core patent in a whole cluster or in a family of patents. But there is no further distinction in patent law, but the Commission seemed to have some kind of bias against such process or secondary patents. And so according to the Commission, there was a kind of set of strategies, a whole set of agreements that was used to delay the entry. And in its press releases, the Commission was also making quite strong claims that the Commission will not tolerate this type of practices, that it was really unacceptable and that it would harm patients and national health systems. So you see that there's quite some public interest aspects that is not necessarily all based on competition law concerns that are woven into the policy documents or press releases that are issued by the Commission. And so considerable fines were imposed on Lundbeck, on Merck. And so this was a really important case. So in terms of the actual or potential competition, what did the Commission look at? There needed to be some kind of demonstration, which should be based on not on a mere hypothesis, but there should be factual evidence of that. There should be more than just a pure theoretical possibility of market entry. Let's go to the next slides, where then in terms of the presumption of validity, what the Commission is looking at. And remember again that the Commission is, of course, it has a lot of competition law expertise, but it's also thinking about this presumption of validity, which is very much a patent law issue. So would it have been possible to enter the market sufficiently quickly, despite the patents that were there, and despite the patents which presumably are normally valid? And so what did the Commission take into account? And I already pointed to that also before the break. So were there significant investments by the generic company to start preparing entry to the market? Because as I indicated before, also the generic company needs to have a marketing authorization. And in order to acquire that, also needs to provide all kind of data to show the effectiveness and the safety. And so the question is, did it already obtain such a marketing authorization? What about the processes? Because there were process patents. Are there also maybe alternative processes that can be used that would not be considered infringing on those later process patents that Lundbeck applied for later? Then also, what was basically the chance, the possibility that the patents would be invalidated? And so basically also an assumption that that chance would be higher in case of process patents. And I also mentioned, I think this in the first session, so process patents are often regarded as harder because they're harder to enforce. So I explained then that you cannot just enter the factory to check what kind of process a company is using. There you would need special remedies to be able to do so. So in that respect, process patents are maybe less popular than product patents, than compound patents in the area of pharma. But the fact that there would be a kind of high, or the assumption that there might be a higher likelihood of invalidity for such process patents is maybe not fully justified from a patent law perspective. And then, of course, the Commission also took into account as a very important factor that there were significant payments flowing from Lundbeck to the generic companies. So the Commission was also taking into consideration, and also rightly so, according to the General Court, the objectives and the economic and legal context, also emphasizing, like I also did with respect to the technology transfer guidelines and the later monitoring exercise, that reverse payments are not necessarily a problem, but if there is a value transfer, the Commission will definitely take a closer look and will look at what does the payment relate to. Is it linked to the strength of the patent? But I already added, again, before the break, how to assess whether a patent is strong or not. That is not always so easy to do. Then also another aspect that needs to be taken into consideration, was it necessary to enter into that reverse payment to find some kind of acceptable and legitimate solution to the conflict that was existing between the two parties? And are there maybe additional restrictions imposed that would further delay the market entry? And so it's really important to check what this value transfer, what does it relate to? So I also mentioned if it would relate to also some kind of distribution agreement or relate to other materials that are being produced maybe by the generic company. And so those kind of payments could be very well justified, but not necessarily. And you really need to take a closer look at what was the link between the value transfer and the actual services that could be provided by the generic producer. And so if the payment would be linked to the profits expected by those generic undertakings, then that would be considered rather problematic. If there would also be some other considerations related to the state budgets, the payment. So this kind of context that I referred to also before the break are all aspects that should be taken into consideration. And then, of course, as always, there could be a justification by the companies in theory. And so this was also tried by Lundbeck. Arguments related to protection of investments, but it was done in a quite generic manner. And so probably for such an objective justification to be successful, you need quite specific justifications for this type of behavior. That could, for instance, justify the value transfer, which should then not be linked to the actual profits that the generic producer would be expecting. In case it would not have been, in case the generic entry would not have been delayed. So what is still interesting in this case as a kind of side remark, so, and this you can also see in US cases related to these patent settlements. So there was also, in the US, there was a discussion on whether a different type of test should be used at to assess these patent settlements. And there was a discussion on the scope of the patent test and whether the actual settlement could be classified under the specific scope of the patent. And here it was clarified that that test was not the test that should be used, but really a kind of factors that I indicated above and that were also already mentioned, that were also included then in the technology transfer guidelines. Also, what you see is also some kind of criticism or implicit criticism of the patent system, because there were some interesting counterfactuals available in this case, because while there was the investigation by the Commission, there were also cases before the European Patent Office, the Board of Appeal. And this is an important actor in the patent system. It's not just the opposition division, but it's the Board of Appeal. The Board of Appeal are kind of quasi-judges, you could say, within the scope of the Patent Office. And so they had confirmed the validity of the patents. And the Dutch Patent Office had also confirmed the validity. But yet the Commission was still presuming that those kind of the patents that were relevant in this particular case, that there was, according to Lundbeck, a higher chance that they would be invalidated. So despite those decisions by patent actors, the Commission still continued to have some doubts about the strength of the patent. So that is quite an interesting point that I think should be regarded quite critically. Of course, I leave it up to you whether you agree with me, but I think this is definitely a weaker point of this decision, and also not necessarily a good signal for the General Court and the Court of Justice to basically ignore that. It gives the impression of a kind of imperfect nature of the European patent system, where there's, in all these kind of regulatory mechanisms, there is an element of uncertainty. And it is logical that originator companies want to limit the risks that they are running, especially with this type of blockbuster, which was also subject to this of this specific case, this specific Lundbeck case. Also, if you look then at the Court of Justice, it is also clarifying that indeed such pay for delay agreements can be a restriction by object, can be regarded as a restriction by object, especially also looking at these value transfers. And putting the barrier for giving evidence of relevant counterfactuals, putting that barrier quite high, and also not making it very easy for companies to invoke particular objective justifications. So where the Commission shows quite some reluctance regarding such patent settlement agreements that include a value transfer, you see a same kind of approach also with the General Court and also the Court of Justice. This was also, you also see that reflected in the Servier case. Again, a quite negative perception of the different settlement agreements, where here there was, it was not only 101, it was also 102, where presumably also Servier was engaging in abuse of a dominant position by entering into that cluster of different agreements that would delay a generic market entry. And also, so the Servier case, the Lundbeck case, I think the Servier case, there's still, the appeal is still pending, if I'm correct. And there's another more recent case also against Teva and Cephalon. And so this is then again related to a blockbuster drug, this time used to treat sleep disorders. Also here, a worldwide agreement, so with a significant impact, where Teva undertook not to put its generic products on the market until October 2012. And so this case is still also pending. So you see that these patent settlement cases are still ongoing, and that there has been, still all a follow-up, you could say, from the pharmaceutical sector inquiry. I will not be able to deal with all of them in detail, but I want to go with you to the case of the GSK generics, which I think Miguel also referred to, because I think in that case, there were quite some important clarifications. Of course, this was a different kind of case because it was a preliminary ruling. So you see, of course, a different approach than when there is a commission decision and there's an appeal to the General Court and the Court of Justice. But there seems to be some more clarification on some of the important considerations to take into consideration by the Commission and by national competition authorities looking at such settlement agreements. Again, also taking into consideration the strength of the patent, even though, as I indicated before, this is not a very easy assessment to make. Also looking at the intention of the generic, whether there's some kind of firm intention by the generic, and whether there is an ability to enter the market and the preparatory steps that have been taken. So the same we also saw in the Lundbeck case, and as important factors to take into consideration in deciding on the potential competition. Also, are there any insurmountable barriers to market entry? That could be the original patent, following up process patents. Also the dispute, is there a true and genuine dispute, or are there particular circumstances that might make you doubt whether there's a true dispute? And again, then the transfer of value. So also in this preliminary ruling procedure that was put forward as an important consideration in those patent settlement agreements. The actual existence and the presumption of patent validity were not really so much taken into consideration in deciding on the potential competition. But the focus was really whether the generic manufacturer has in fact real and concrete possibilities to enter the market despite that patent situation. So I see this, but that is my interpretation, as maybe taking some steps away from really trying to assess the patent. In the Lundbeck case, that there seemed to be more of a focus on patent validity, and here the Commission seems to go more for probably more appropriate traditional competition law assessment, rather than trying to enter into discussions about the strength of the patent. So in that respect, that may be seen as an as not such a bad step. And so also in terms of deciding on the anti-competitive nature of the agreement. Also the pending nature of the invalidity challenge and whether there were actually also commercial interests of the parties to enter in that enter into that agreement are important considerations. So again, like I've also shown before, are there other coinciding agreements, distribution agreements that could be for which the value transfer could have been relevant? Yeah, so this again also relates to that value transfer. Let me see. And the pro-competitive effects. So of course, as this is a preliminary ruling procedure, this is then up to the National Competition Authority or the National Court to determine the existence of such pro-competitive effects. And any minimal or uncertain benefits would be insufficient. So again, like we have also seen in the Lundbeck case, there's a pretty high barrier for showing that there would be pro-competitive effects. And so not really easy for the companies concerned to actually show that there will be such pro-competitive effects. Yeah, this is again the commercial interest, which I already mentioned. And this I have also covered. So apart from these settlement agreements, which are really at a core priority for the Commission within the context of the pharmaceutical sector inquiry and the follow-up investigations in this sector, there's also other agreements that the Commission has been looking at. We do not necessarily have a lot of case law there, as not always also appeals were filed. But there was, for instance, also this co-promotion agreement, which is not very uncommon. But through this agreement, Sandoz was actually abstaining from entering the markets and was getting a kind of piece of or part of the cake from the originator companies involved in this case. And so there was also there a value transfer involved. So it was a co-promotion agreement. So there were, let's say, services provided by the generic company in exchange for that value transfer. But it led also to a significant delay in entry for the cheaper generic medicines, and was regarded by the Commission as a restriction by object. But so here we don't really have a further clarification of that analysis through the case law. So those were all 101 cases, really focusing on the agreements or a combination. I think the Servier case was a combination of 101, 102, potential abuse of a dominant position. And then we move to some other examples, which, according to the Commission, could be regarded as an abuse of a dominant position. And so an example of that is the AstraZeneca case. And so this case was also discussed by Miguel, I think in the first class, briefly. And then he also already mentioned, or he showed to you that he was probably not very supportive of classifying that type of conduct also as abuse of a dominant position, because basically this is the use of procedures at the European level, at the national level. And as I indicated before, when I was describing the special characteristics of this market, sometimes these are also just gaps or unclarities in the regulatory context. And so the question then is a use or misuse of such procedures then also necessarily an anti-competitive conduct? Is that also abuse of a dominant position? Of course, you first would need to define the markets and the dominant position. But as I also indicated during that class, quite often the market is defined in a very narrow manner. And that also happened in this AstraZeneca case. So this related to ulcer treatments and a particular group, the proton pump inhibitors that are used to treat infections in your stomach. I have to say I'm not really an expert in this particular medical treatment, but so it is a kind of subcategory of ulcer treatment drugs that work specifically on the acids in the stomach. And so what the Commission did in its definition of the markets, later also confirmed by the courts, is really focusing specifically on those proton pump inhibitors. Indicating that other types of alternative ulcer treatments would not be regarded as a part of the relevant market. So then you can imagine if the market is defined in such a narrow manner, which does not always happen with pharmaceutical products, but often because the Commission is using particular classes within the health regulatory framework to help define the relevant market, also focusing a lot on the therapeutic use itself. Often the market is defined so narrowly, so also much more easily you would come to the conclusion that there is a dominant position if there is no sorry, alternative. Okay, let me take a sip before I continue talking. So you can imagine if the market is defined so narrowly that also relatively easily you would come to the conclusion that the company has a dominant position. And if then also the conduct that you're looking at is a little bit controversial in terms of, is it really considered abusive or not? you can imagine that it led to a lot of controversy in this case, and it's still very controversial. So there were two different types of abuses that were considered here. On the one hand, misleading representation to patent offices and courts with respect to these supplementary protection certificates. So remember that, so you have a patent, 20 years, and just in the pharmaceutical sector, you have these supplementary protection certificates that you can get and that are actually created because it often takes so long to get a marketing authorization. So that's the justification of having those additional rights, but you need to fulfill certain requirements and you need to provide quite some information. And there were different views on the information that was provided by AstraZeneca, whether it was really misleading or whether there could be some kind of misinterpretation of the rules. Maybe the rules were not absolutely clear, but of course, this there's a lot of health experts at AstraZeneca. So also some people were saying, okay, they were also using the interpretation which was potentially most beneficial for AstraZeneca, but is that necessarily an abuse? So that's something that you can dispute. But the Court of Justice and to the Court of First Instance, now the General Court and the Court of Justice, both came to the conclusion that indeed this type of misleading representations can also be considered abuse of a dominant position, that there was no competition on the merits, and that actually dominant positions do have a kind of special responsibility when they are providing this type of information. And so knowing that quite easily, the Commission comes to the conclusion that a company in the pharmaceutical sector is dominant. Basically, you could say that a lot of companies active in the pharmaceutical sector have those special responsibilities. So basically, you create an additional requirement or burden in terms of the quality of information that is provided to patent offices. So through competition law, you create additional requirements within the patent system. So that's quite an interesting dynamic there. The second abuse was not misuse of procedures in the patent system, but in the marketing authorization procedure. And as I said before, part of that procedure is happening at the European level before the Medicines Agency, and part of that happens at the national level. And so what did AstraZeneca do? They were deregistering the marketing authorization of their own capsules, then making it harder for generic companies to actually get a marketing authorization for the generic producers. If the originator, if the original product is no longer listed, you can imagine that also registering tablets that would be put on the market by a generic company would be made harder. But so the question then is that a kind of loophole in the national legislation, and that deregistration by AstraZeneca would automatically also have consequences for the possibility to get marketing authorization for generics, and that they could no longer use that abridged, that sort of simplified procedure, as long as there was no registration of the marketing authorization for the reference product, so the original product. So is that a loophole in legislation? Or if that loophole exists, is that an abuse of a dominant position? And so here, Commission imposed a significant fine. The Court of First Instance was reducing that fine. And there the Court of Justice was looking a little bit more significantly also at the objective justifications and the regulatory burden. So this is quite interesting in my opinion, because here the argument of the objective justifications for engaging in a particular conduct is, I think, taken more serious than we might deduce from the pharmaceutical sector inquiry and some of the previous cases. So this is, I think, quite an interesting element of this case at the level of the court. So that was for the kind of misuse of procedures as a potential abuse of a dominant position. Other types of practices, so I've already a few times alluded to all kinds of communication strategies that are being used by the originator company, by the company with a dominant position, aimed at physicians or pharmacists or patient groups, alluding, for instance, to the presumed unsafety of the generic products. And so also here you see some examples of cases by national competition authorities where such kind of conduct, such kind of practices were also considered as abuse of a dominant position. So just to give you a few examples, and especially also in France, there have been a lot of cases like that, just to as a kind of showing that there have been various cases also like that in France. So I already mentioned that UK, that is, I think, the CMA, the competition authority in the UK and in Italy have been quite active when it comes to cases in the pharmaceutical sector and also excessive pricing. And this is where we are now. So as I said before, the United Brands criteria, where there's this distinction between, first, that you need to show that there was excessive price, but also an unfair price. And then the price can be unfair in itself, or it can be unfair by looking at competing products or comparable products. But then, as Miguel also mentioned when he was discussing the United Brands case, but also this Latvian collective societies case, and so those cases were discussed last week. He also said it's often not so easy to identify comparable products, especially in a market which is very innovative. When this is about very novel and innovative products, often you don't find an equivalent. Or also, if you look at the pricing of intellectual property rights, this is all about innovation. So really finding a comparable of products or rights to look at is an additional challenge in this type of excessive pricing cases. And already in general, competition authorities are generally quite reluctant. And I think also Miguel also said it last week, probably rightly so, because competition authorities are no price regulators. Also, what price regulators do is they ex ante, they would assess a price. But what competition authorities do is, of course, an ex post assessment of particular conduct and behavior. And so in general, competition authorities do not quite easily invoke grounds that relate to the pricing, or especially not excessive pricing. But lately, both by the Commission, but also by national competition authorities, you see an increased reliance on that argument that companies are engaging in excessive pricing behavior. And again, that is in response to health authorities that are so concerned about the health budget, the pressure on the health budget. So also competition authorities are involved in that policy decision to take action to do something about the prices in the health and pharma sector. So this probably explains why lately there have been an emergence or an increase in cases related to excessive pricing in the pharmaceutical sector at the national level. And so also a case at the European level, the Aspen case. And so why is there that reluctance? Because of the special characteristics and because of the fact that it's so highly regulated And so it's not a normal price setting environment where it's actually offer and demand that would determine the price. No, the sector is highly regulated, and so the price is being determined also by health authorities in dialogue with the companies. Is that an equal situation? How powerful are these national authorities that are involved in determining the price? Probably that depends also on the country. So a small country like Belgium, probably the Minister of Health is not in such a powerful position when it is negotiating prices for medicines for which there is no alternative, but where the company has a very strong IP portfolio and really is eager to set very high prices. So a very complicated market, and also very difficult to know how to decide on what is excessive and what is unfair. And also very difficult to know what type of economic methods should be used to evaluate what is excessive and unfair. So if you look, and I mentioned before the cases before the UK Competition Authority. So there have been various cases where this is also tackled, and where also the UK courts, the Competition Appeal Tribunal, I think it is CAT, has also had some doubts about what is the best assessment methods. Should it be cost plus or some other kind of methods? And also what kind of comparators can you use to look at the pricing of the company concerned and other companies? How can you really compare that in such an innovative market? So you see that national competition authorities really have had a hard time in looking at this excessiveness. And in determining the methods, the economic methods, and also in getting access to the data, because how can you how can you determine the costs of research and development, the marketing costs? It's the companies that need to give those data. And so what you see in practice is that companies sometimes say, yeah, we don't have those data, especially European subsidiaries would say, okay, we cannot really give you more information than what we have already done. And competition authorities have had quite a hard time making those assessments on the pricing strategies of presumably dominant companies. And so I've been in touch also with the Dutch Competition Authority that has recently issued the decision in the Aspen case, also dealing with excessive pricing. And it took them really long to come up with a decision, also to come up with the final and very detailed official decision. I think there was a very long time between the moment that they published their decision and the moment that they actually also gave the public version. And I think we still don't have the complete version available on their website. And the same you also see if you look at the website of the UK Competition Authority. So really getting a good grasp of how to determine what is excessive, what is unfair. And so how do you do the evaluation is really quite tricky in these cases, which explains the reluctance. But then the big policy priorities in terms of health budgets, that explains why we do see, despite the difficulty of making that assessment and despite the reluctance, we do see an increase in such cases. And so what cases do we see then? If you look at the Aspen case, but also at the Pfizer and Flynn case, which is a case in the UK, is you see that in these cases, the price increases have been not just like 10% or 20%, but we're talking about 300% or 1500% increases of prices. So these are really extreme examples of price increases, where also often the company concerned was not the company that did the R&D investments. So in many of the cases, so I've done a little bit of a comparative analysis of different cases, the Aspen case, and then the various Italian cases and UK cases. So in those cases, you see that most of the time the company that is now selling the product was not the original company that actually developed the product. So the original company sold the product to another pharmaceutical company. And then this, let's say, company B that bought the product and the IP the relevant IP portfolio, they didn't invest in further innovation, and still they increased the prices, not just a little bit, but significantly. And so the fact that that company itself didn't engage in a lot of innovation is an important aspect. And that so in the process of increasing the prices, there were not a lot of justifications for those price increases. And often also in those cases, there was no alternative treatment available. So patients were really dependent on those products. Sometimes these were also really niche products for a very small patient group. And so that small patient group was completely reliant on only this treatment. And so many of these cases that we see in excessive pricing in the pharma sector are quite specific in the fact patterns. So I think this is really a very important lesson to take from this, is that what is excessive is really only applied both in this Aspen case, but also in the cases that we have seen before the national competition authorities with major, really significant price increases. And that also resonates with what Miguel said the last time, that also you find that where it's significant, you also find that in the more recent case law, and also the Advocate General in the Latvian Collective Societies case also emphasize that really significant increase of the price before you can actually conclude that. And so in these cases that we have seen in the pharmaceutical sector, the price increases were really in the hundreds of percentages. So really very extreme cases. And so other investigations where the percentage was really much smaller have either not come to a final decision, or they're still pending, or cases where there was more innovation happening. Also there you see that cases are either still pending or there was no final decision. And so so especially also those national decisions are quite interesting to look at. So here you see some information on the Aspen decision and the commitments decision in that particular case. But the considerations also in that decision, if you look at the assessment methods and the way that the Commission is looking also at the United Brands test, very, very similar to the considerations by the UK CMA, also by the Italian Competition Authority, by the Dutch Competition Authority. So you also see that they are collaborating on these cases and that they are exchanging quite some information, not only within the context of the EU, also within the context of the OECD. There are regular meetings that deal with this excessive pricing because it is an important priority. It is an important priority for health authorities and an important priority for competition authorities. And for the competition authorities, especially because the analysis is so complicated to make. Here you have a few other examples of national cases. So this Pfizer case where there was also an appeal and ultimately a final decision. And also in Denmark, there was also another excessive pricing case. So you see here, what are the increases? It's not 20%, not even 50%, but it's really a price increase up to 2,600%. So this is really significant, to give you an example. And also the case in Denmark, also there was a price increase that was assessed at the level of 2,000%. So another really significant price increase. Then the last example that I want to mention, and then you can take another short break before Miguel will discuss further the topic of standardization, is another case which is still pending before the European Commission, a case related to TIVA. So here a formal investigation has been launched, so there's no decision yet. So this was a treatment, or this was a medicine that is used in the treatment of MS, multiple sclerosis. And as you may know, there is no truly this disease cannot be cured yet. So this treatment is especially to improve the quality of life of the patients, and it's a really important medicine that is being taken. The active ingredient or the patent related to the active ingredient expired in 2015. And what TIVA was doing, it was engaging in filing for such divisional patents. So this is one of the other types of strategic behavior that the Commission already identified in the pharmaceutical sector inquiry as part of the toolbox of potentially anti-competitive behavior. And so, as I already explained, these type of divisional applications are very common. So it's cases where there is one patent application which is still pending, a very broad patent application, the parent patent application. And then while this patent application is still pending, so the assessment has not yet been finished by the patent examiner, the patent has not yet been granted, but so as long as there is no ultimate decision by the patent examiner, you can file for divisional patents related to subtopics of this first and earlier parent patent application. And so as a result of such strategic patenting behavior, there is often a large family of patents, sometimes with overlapping inventions. And so what does that mean? If a competitor wants to challenge the patent, it's not sufficient to just challenge the validity or or oppose while the patent is still pending the parent application, but you also needs to address the divisionals. So if there's many divisionals, and if sometimes the company also retracts certain divisional applications and then files for new divisional applications, you can imagine that that requires a big investment of other companies who want to challenge those patents. So according to the Commission, that could be that kind of strategic filing and withdrawing of divisional applications could be anti-competitive. And so you could say that this is even a step beyond what happened in the AstraZeneca case, because in the AstraZeneca case, there was still misleading information which was given to the patent office, even though you could have different opinions as to the interpretation of the law, but presumably it was misleading, and that was, but here, this is the information that is provided fits within the normal requirements of the patent system. So it's one step beyond AstraZeneca, you could say. We don't know whether indeed the Commission will come to the conclusion that it is abusive behavior, but I have heard some presentations by the chief economist of DG Competition that has been quite negative about divisional patent filing strategies. So I would not be surprised if the final conclusion would indeed be that it would be anti-competitive, but we don't know. And so apart from the strategic filing, also in this case, there were also a similar kind of communication campaigns addressing health professionals, like I've already mentioned before. So there's also two types of conduct. On the one hand, these divisional applications, and on the other hand, also such kind of disparagement or disparaging information which is given to health professionals to discourage them to actually prescribe the generic product because it would presumably be unsafe. So it remains to be seen what will happen with that. And so now I would like to briefly conclude. So you'll have a few minutes to prepare to go to a different sector to start thinking about standard essential patents and not necessarily standard essential pharmaceuticals, which is a little bit what we have been seeing here. So pharmaceuticals for which there is no alternative. So the pharmaceutical sector is lately getting a lot of attention. So this is something from the last 2 decades, basically, within the context of the EU, but not only in the EU, also in other jurisdictions, especially also in the US. There's a lot of cases related to patent settlements, and also in other jurisdictions, the attention has been increasing because of this big concern about the growing health budgets or the growing costs for healthcare, expansion of different types of conduct covered by 101 and 102, like you have seen in the AstraZeneca case, and which we also see in the pending investigation in the Teva case. Also an increase in excessive pricing cases, even though there is typically a reluctance to conclude that there is excessive pricing, but we have seen an increase in such cases, both at the European and the national level. A kind of special responsibility for pharmaceutical companies, for companies that are often dominant in the very narrowly defined markets within this sector. Also a growing complexity of pharmaceutical and biotech products, where also within the context of personalized medicine, we sometimes see that people are also starting to talk about standards, especially linked also to the use of diagnostics. And so one sees also a discussion growing about standard essential patents and whether maybe the considerations about friends should also be something that could be useful in the pharma sector. I'm not sure whether it will help. Maybe it will just further complicate things, but this you will be able to judge after Miguel's presentation. And so also what you see in many of those cases is the relevance of internal documents, because the Commission has used those documents to really express doubts about the strength of patents, challenging the normal presumption of validity that we have in patent systems. And so this is, I think, especially for those of you who are practitioners, really a very important point of attention, because the Commission has been using them in a rather important manner, or in influential manner, is maybe a better way to put it, especially also in those patent settlement cases. And then I would like to finish here. I will still be in the session. So if you have some burning questions, I'm here to respond to them. If you don't have questions, maybe take a break of, I don't know, Miguel, how many minutes do you want to give for a break? 5 to 10 minutes, maybe. And then we can go to the other topic. But for those of you who have questions, I'm here, and don't hesitate to ask me anything you would like to hear about this.
Yes, thank you, Esther. I would say 10 minutes, it's fine, but it's really up to you. No, let's meet again at 20 past 4. If that's okay. Thank you. Miguel, that's okay? Yes?
Yeah, it's fine. That's fine.
Okay, great. Thank you.
All right. Shall we get going?
Yes, yes. Good afternoon. Miguel, how are you? That's fine. Can you hear me?
Yeah, I can hear you just fine. Let me try just to share my screen.
Yes, if you can.
Where is-
Yes, perfect.
Can you see it?
Yeah, thank you very much. Okay.
So, hi everyone. This will be the last portion of our module. As announced, we will speak about competition law and standardization. And I'll try to wrap this up in, let's say, an hour 45. We'll be a little bit over the 6 o'clock finish. I guess by now you're all familiar with the idea of standards, with the notion of standards, the notion of standardization. I put here a few definitions about what a standard is, but the best way to think about it is that a standard can be essentially any set of technical specs that are meant to provide a common design for a product or a process. Think about it as a standard is the blueprint to make something. Sometimes to make things that will work together, they need to interoperate products or systems or processes. Now, it's a very sort of high level, 10,000 feet view. Standards for our purposes, and you'll see that we will devote quite some time and focus on wireless or mobile communication standards. But these observations or these definitions, they apply to pretty much any standard. They are created by standard setting organizations or standard development organizations. I tend to prefer the standard development organization term, SDO, but it seems like SSO, standard setting organizations, has now won out, at least in Europe. But it's better to think of these organizations, at least the important ones, as standards development organizations, because they develop standards rather than just setting them. Setting seems too abstract. Examples of standards that everyone knows: the standard for electric sockets. You will have a common standard, or sometimes you'll even have several common standards, or sometimes several generations of standards in a given country. Sometimes these common standards will apply to a region, a large region, perhaps a series of countries, sometimes for historical reasons, others for political reasons. And the electric sockets essentially ensure that if you're in the United Kingdom, when you buy an appliance, the appliance will allow you to connect it to the power sockets on the walls. The same appliance bought in the United Kingdom, as you know, will probably not work if you bring it to Belgium, because you'll have a different standard for the electric sockets. So everyone can guess this. And then you have more complicated things, DVDs, for instance, the all-important communication protocols, such as the one behind the internet, HTTP. or the second generation mobile GSM, which was so important that in fact, in many French-speaking nations, essentially GSM is used interchangeably with mobile phone, but it's just the second generation of phones. Now, all of these SSOs, they've gained tremendous importance for obvious reasons in all of the technology-driven sectors. You have more and more products that have to work together. Interoperability between devices and compatibility amongst products, as we can surmise, is critical. It's very important to promote innovation, to promote competition. And it's been particularly important in the IT and the communications tech sectors because of network interoperability, to make sure that we can have vast connected networks with seamless flows of data. Right. What kinds of how can you classify? This is just, you know, my classification or categorization of types of standards. You can have private standards set by private parties. You can have public standards defined or endorsed by a government organization. For instance, a state will say, well, henceforth in this country, all products of this type will have to obey these specifications, and a law would be passed. That would be a public standard. You can also have de facto standards, which means that consumers have, through their choices, created a single standard. There's a few that you can think of. I'm sure, for instance, for a long time in the software realm, essentially Microsoft Word was a de facto standard. And it was just a result of consumer choice. One might also say of network externalities, but essentially of consumer choice. For obvious reasons, competition law is essentially concerned with private and de facto standards, not with public standards. That's public prerogative. We may have some issues with public standards from an EU law perspective, but not the EU law of competition. As regards de facto standards, you have one company which may end up controlling a product or a protocol. The conduct by that company could breach Article 102 if it has, because it has given rise to a dominant position. The market is essentially the standard. And then you can have issues of a refusal to deal, or in our case, a refusal to license some IP. You could have issues of excessive pricing. We've covered all of these things during our lecture on Article 102. What are private standards? Well, the private standards are, in effect, agreements between private companies. Sometimes they will involve, as is the case for the one I'm the most familiar with, the standards that relate to or support wireless communications, mobile communications. Those are very complex standards. They're set by a very large number of people. These individuals often work for rivals. What are the issues that could affect these private standards? Well, you could have violations of breaches of Article 101 because these are agreements, right? They're agreements between different parties. It can also be, there can be issues relating to the application of the abuse of dominance prohibition. If the SSO or its members hold a dominant or a jointly dominant position, because, and we will see, a SSO could have a dominant position in a market defined, for instance, as the market for standardization of a certain product. With this said, just as in everything we have reviewed so far, the existence of any restriction of competition presupposes a detailed factual inquiry. It is always a fact-specific assessment, with the few exceptions that we've gone over that are the result of these almost per se abuses, such as in AstraZeneca. But why is it particularly important to bear in mind that in the standardization context, one needs always to examine all of the facts? Well, simply because, as a rule, the purpose of standards is to promote competition. It's not to restrict competition, it's the opposite. Some of the recognition of this basic reality goes back many years. I have here a communication from the Commission on IPR and standardization that is over 30 years old. It recognizes that the objective of formal standardization is to generate economic benefits for society. And these are the result of what? Of a rational organization of supply and demand, which increases competition in the marketplace. How does standardization bring these things about? Well, it reduces costs for suppliers and for purchasers of goods and services. That's consumers. Another more recent communication from a few years ago concerns the licensing of these standard essential patents, to which we also have alluded. And the Commission's communication, in a nutshell, again, recognizes the importance of standardization and then makes some general policy statements that set forth what the Commission thinks could be done to improve matters as regards the licensing of SEPs. Now, we'll go through the application of Article 101 to standards, and also the application of Article 102. So how does competition law intersect with standardization? Starting with Article 101, how does it apply to the context of standardization? Again, Article 101 applies to agreements or considered practices. So one has to distinguish between, on the one hand, the standardization process as such, right? So the efforts undertaken by these organizations to create a standard. Their rules, the institutional rules, so to speak, that govern the formal SSO. And as we shall see, these rules relate, sometimes they're referred to as the bylaws of the specific organization that sets standards. They concern matters such as who can be a member. Once a standard has been adopted, and sometimes these organizations, they adopt multiple standards, how is access granted to the standard? Are the specifications published? If so, where? What are the rules governing the technology that goes into the standard? Are there rules relating to the way in which members have to behave when the standard setting work is taking place? What do they have to reveal? How will any IP that is incorporated into the standard license? So that's standardization as such, the rules that govern it, like the laws of the specific institution. And then there's something different, which is the particular standards that are to be adopted. So for instance, the standard relating to electric sockets of 1999, right? There will be one standard. And then you have another standard maybe a decade later. Or you might have concurrently separate standards for different things. Article 101 can also apply to the particular standard that has been adopted. The document that sets out the European Commission's approach, well, before I say that, I may have said this already in the past, but if not, I will repeat it. Standardization has become so important in the last couple of decades, and the intersection between standardization and competition law has simultaneously taken on such importance that the European Commission some years ago introduced a new chapter that concerns specifically standardization in its horizontal cooperation guidelines, chapter 7. By the way, the guidelines are now in the process of being revised. It's almost done. They haven't been formally enacted yet. And there's some important amendments that have been made to the section on standardization. So guidelines, Commission guidelines on horizontal cooperation agreements, they have a section on standardization. The guidelines apply and provide guidance on how the Commission applies Article 101 in the context of cooperation between rivals. Strangely, the section on standardization contains guidance not only on Article 101, but also on Article 102, on the abuse of dominant prohibition. It's also in there. So that's the sort of the guiding document for the purposes of the application of competition law by the European Commission. And they contain some good things, and they also contain some bad things, and contain some things that are just wrong. But they're a very useful starting point. With regard to standardization, the guidelines tell us, and this is a very important statement, that when participation in the standard setting process is unrestricted, anyone can join. The procedure for the adoption of the standard is transparent. And where the agreements adopted by the given SSO do not contain an obligation for the members to actually comply with the standard, and when access to this standard is allowed on fair, reasonable, and non-discriminatory terms, a sort of safe harbor is created. That means that standardization will normally not restrict competition within the meaning of Article 101. So where you have these things in the bylaws of the specific SSO, it's highly unlikely that the SSO would ever have a problem under EU competition law. So that's for, again, that's for the institutional framework, the bylaws, the rules that determine how the standard setting organization works, who can be a member, etc., etc. Things are a little bit different now downstream, which is once a specific standard has been adopted. And with regard to these specific standards, once again, in order for us to find out whether they can restrict competition, we have to look at the things we already looked at when we're discussing the general application of Article 101 to licensing, for instance, right? You need to think of what happens in the market. One has to look at inter-standard competition, right? Standards that compete against other standards. And one has to look also at competition between standardized and non-standardized products. So what does inter-standard competition means? In many product markets, you're actually going to find that you have products that compete with each other that are based on different standards. One textbook example is the example of the first video cassette recorders, VHS and Betamax. You had two separate standards. They were part of the same product market for video cassette recorders. They competed with each other. Eventually, VHS won. And very shortly after this vigorous competition took place, essentially Betamax, which was a creation of Sony, it essentially stopped being produced. And in the United States and in China and in Korea and in many other nations, you had communication between rival standards for mobile communications. That has not been the case in Europe. but in the United States, in China, in Korea, etc., many other countries in South America, different networks operated under different standards. In China, you had simultaneously UMTS, TDS, CDMA. In South Korea, you had CDMA-based standards competing against UMTS. Just to give you an idea of, in Europe, that's not the case, but you can have competition between standards. This competition can take place, obviously, if you at the level of the technology and also at the level then of the products that incorporate the technology. But you can also have competition with things that don't actually obey any given standard, just a proprietary product or technology sold by a given company. These forms of competition are obviously recognized in the horizontal cooperation guidelines. So with that said, what are the types of restrictive effects that could affect standardization agreements? Well, they're not all related to IP. We'll cover all of them. The first is obviously a reduction in price competition, the cardinal sin of competition law. How would this happen? Well, this would happen if within standard setting organizations, the members would discuss the fixing of the prices of the products that then they would sell that conform with the standard, or the prices of technology that is seen as a substitute. That's the first type. Another type of restrictive effect would be the foreclosure of innovative technologies. How would that happen? Well, we can imagine a case in which there's some standard setting going on. The members of the standard, they all get together and they're trying to discuss the technologies that would go into their standard for something. I often give the example of something as simple as we're creating a standard for water bottles. What shapes, how would they be made, the materials used, etc. And once you've selected something and you've written it down and it's become part of a specification, well, some technologies will have been selected, others, well, they would not have been selected. What would happen to those technologies? They might face barriers to entry into the technology markets. It might be the case that because a standard has been adopted, there would be no further uses for that technology. The case of, a single standard that would then, by virtue of some public measure, be adopted as a single standard across a territory. This could be an issue. It could foreclose technologies, for instance, where all of the members of the standard setting organization, as a result of their membership, are forced to use only the technologies that have been standardized and no others. Or where, for instance, because they're members of the standard setting organization, they have essentially committed to, when they're selling products that comply with the standard, not making products that would comply with other rival standards. So those are just, examples of highly stylized examples of circumstances one can imagine where the standard setting process would lead to technologies not finding buyers, takers. And then the third type, of course, is the exclusion of or the discrimination against companies because they can't have effective access to the standard. They would not have either access to the technical specifications themselves, so what is the standard? What are the documents that tell you how do you make these water bottles, or how do you make these phones? How do you ensure that they communicate, right? The technical specifications, or access to the IP is limited. Limited how? Well, because they don't have the right to obtain a license to the IP, or because they only get access on discriminatory terms. You, as a result of this lack of access, or of this discriminatory access, companies that would like to make products that comply with the standard would either not be able to do so, or would do so at a cost. So these are the main types of restrictive effects.
Can I ask a quick question?
Yes.
Thank you. Regarding the second theory of harm and restriction of innovation, is there actually any case law where such a restriction of innovation was found? Because in most standard setting scenarios, the companies that are involved will obviously have an incentive to rely on the standard. So absent any obligation to comply with the standard, you would normally assume that there is no such restriction. But in recent discussions with the competition authority, it seemed to rely quite heavily on the possibility of there being a restriction innovation simply by the companies involved deciding on a specific standard and maybe some kind of new focus on a restriction of innovation. So are you aware of any such case law?
Well, as you're going to realize soon enough, there isn't much case law at all, let alone on the most intricate aspects of standardization. So the short answer is no, there isn't any case law. There's no case law at the EU level, and to the best of my knowledge, there really isn't any case really on point at the member state level. What you have is you've had claims. There's been, claims made in litigation, claims made in internal administrative processes within the important standard setting organizations, both in Europe and in the United States. So the argument as such, or the possibility, has been dealt with, albeit not at a level that would have resulted in actual judgments, or even commission decisions, to be fair. But there's been ample discussion. The Commission itself has intervened on several occasions by addressing letters to, for instance, Etsy. Famously, some years ago, during some controversial discussions that took place within Etsy, which is the European Telecommunications Standardization Institute, the most important SSO probably in the world, but certainly in Europe, discussions regarding modifications, amendments to their bylaws. The Commission has on more than one occasion written to say these proposals that are being discussed, they may well be anti-competitive, and they may result in a foreclosure of technology, lessened innovation. So ample discussion, but nothing that would come close to a clear legal standard on what would have to be shown, an analysis, a full-fledged analysis under competition law. And there are the discussions, for instance, at the IEEE in the United States, with certain rules which certain members alleged were meant to boycott the technologies that they wished to contribute. So there's fierce jousting within some of the SSOs to have IP included. So you can imagine how there may also be, efforts, but we're not really talking about those here. The ones I've, listed really are the ones where it's clear cut. For instance, the rules of the SSO say, if you are a member of the SSO, well, you cannot manufacture products that comply with another standard, or you can only use this technology for the production of goods. And then, you end up with a situation where there's only maybe one SSO in a given field or in a given industry. We can imagine hypothetically how this would result in the foreclosure of technologies, although in practice, this seems to not be really a major issue.
Thank you.
Again, the types of analysis, the effects, some by object prohibitions under Article 101, where, again, the cardinal sin, in fact, the SSO is simply a front for price fixing. That's a restriction by object. Now, for all other standardization agreements that don't actually have the goal, the aim of fixing prices, etc., we need to apply the rule of reason. We need to analyze actual or likely effects on competition. I've heard the paragraphs where this is recognized in the useful Commission guidelines. The Commission guidelines have, as I've said, this safe harbor, which essentially says where the rules are so and so, generally speaking, it's highly unlikely that you're going to have any effects. So standard setting organization, if you're creating a standard setting organization from scratch, if you have these elements in your bylaws, nothing is going to happen. So unrestricted participation, access to the specs, so access to the sort of the blueprint, what is the standard, how does it work, then access to the IP on these friend terms, because the members of the organization will say, listen guys, if my technology, which is covered by some patents and some patent applications, if it's included in the standard, I promise that I will grant licenses to anyone who's interested on on friend terms. This is the friend commitment, and the friend commitment has essentially been the rule and the basis of standard setting in the tech world for well over 5 decades. And then the last point, good faith disclosure of IP that might be essential. So this is the act of when you're the member of the SSO, you know that the technology, that it's easier to make this a bit more granular. Within an SSO such as Etsy, you're going to have a whole bunch of engineers. In fact, so many engineers that you'll have very many different committees or subgroups, each of them working on a specific portion of the standard. These are Etsy standards for mobile communication. So a group may be discussing, let's say at a very basic level, how the cell towers, communicate with the antenna on the phone. And then another group or another committee will be dealing with how the radio portion of the phone will actually work. So they're in committees, they're discussing. These guys are engineers. Well, we should do this, we should do the other. We think that this method is better. Well, the other method has these advantages. You can see how this goes. This notion of the good faith disclosure of IP means, and these people are generally representatives of companies with interests in the industry, and they want the best technical solutions. They're only interested in the best technical solutions. When they come to the choice, the selection of some method, some technology, one of them will say, wait a second, if we go down this path, my company has or may have some IP which will be then essential to implement the standard. This is my simplified version of good faith disclosure of IP. The company discloses to the SSO that a certain technological path will necessarily involve IP that it owns. So that's for the safe harbor. If you do these things, generally no problems. What happens if the rules are somewhat different? They don't provide for maybe an obligation to license on friend terms. The members don't actually need to give a commitment. It's not provided for. Or the rules don't say, oh, you need to disclose, or the rules say only companies of a certain size can be members of the SSO, or the rules say only members will have access to the specs. Well, if that's the case, they don't comply with this, they don't fall, rather, into this safe harbor, but that doesn't mean that they will necessarily breach the breach Article 101. What that means is, just like other safe harbors, like the safe harbor in the technology transfer block exemption regulation, if you don't fall within the safe harbor, you need to look for yourself. You know, you need to conduct a self-assessment to see whether bad things could happen, whether competition might be restricted. And once again, you have to analyze everything in the full legal and economic context. A few things. In the absence of market power, it's highly unlikely that you're going to have restrictive effects on competition. In most cases, and you have to bear in mind that there's tens of thousands, not more, of standards and standard setting organizations, some of them very, very small. In most cases, you're not going to have any restrictions of competition as a result of these rules. How do we know this? Well, we can very well imagine that if all of us here now at the BSc decide that we are going to create the BSc standard for water bottles, and our rules are super strict, you know, only the students and the teachers have access to the specs. If we have any IP, we won't license anyone. What's going to happen once we've come up with our little specs for the water bottles? They have to be 50 centimeters high, transparent, with a round cap. Nothing will happen. We'll have absolutely no impact on competition. And that's despite the fact that we will have our own SSO, we have very strict rules, and we've actually adopted the standard. But, you know, we're not going to affect anything. So think about it in this manner. It's true, some SSOs, they're complex. They play a very important role in a product market, but one should not imagine for a second that once one comes across standard setting or a potential or an existing standard, that the most likely effect is that it's going to have any restrictive effects on competition. In most cases, zero. In the overwhelming majority of cases, there will be nothing. And in some cases, you may have some issues. I've advised on the creation of standards and of SSOs. Some as small, essentially, as a sort of informal arrangement between a few rivals, with all sorts of obligations for them to comply with the standard, no need to disclose, no provisions on IP. And the advice was, there's no risks whatsoever. Because despite the fact that you're rivals, despite all of this, this is unlikely to move the needle. You cannot be expected to have any market power either at the level of standardization. There's a bunch of other standard setting organizations to which people can turn. You're not going to have a negative impact on technology markets, and your likely market share on the product market is also likely to be quite trivial. Wow. Now, how does IP fit into all of this? You know, I've already alluded to this previous classes. You know that many of these standards, well, they're going to incorporate technology that is essentially covered by IP, such as, for instance, patents. But it can be other things. You can have standards that actually also include trademarks. What does it mean to have a standard essential patent, right? That means that it is not going to be technically possible to implement the standard, meaning to make products that comply with the standard without infringing the IP. In our case, if you want to make the bottles of the BSC that are round and 50 centimeters high and this and the other, you're going to have to use a process which we have developed and which we have patented to manufacture the glass. There's no other way. If it's going to meet the BSC standard, it will necessarily have to make use of our patent. So that's an essential patent. Obviously, the availability of this IP will be key to determine whether the standard is available to others. The obligations for the members of the SSO in relation to the IP, they're usually contained in the SSO's IPR policies. Generally, in their bylaws, there will be a section that says intellectual property. How do we deal with intellectual property? What are the duties for the members of the SSO? So those are the all-important IPR policies. Under these, the traditional standards development procedures, again, based on the friend licensing regime or system, the IP owners who are members of the SSO, who are discussing these technical solutions, they will disclose the ownership of the patents that may be essential. There's no certainty. They may be essential. This is the process of raising your hand to say, hey, if we're going down this path, company A, we may have some IP there. And then generally, in those cases, the IPR policy also specifies that if that's the case, the member will say, we will grant licenses on friend terms if that IP is included in the standard to all comers. Now, this is a very important commitment, obviously. Why? Given that the essential function of IP, or the essential element, is this right to exclude others. Well, once you give friend commitment, you're doing what? You're foregoing this essential element of your intellectual property right. And then the specific terms under which the licenses will be granted, well, they're typically negotiated on a bilateral basis between licensor and licensee, so between IP owner and the company that wants to implement the standard outside the SSO, not done through the SSO, between companies separately. Again, turning now to the concerns under Article 101 that relate to IP. Well, I've set out 4 here. The first is, again, the cardinal sin of competition law: price fixing. Some members of the SSO, they would agree on the prices, so the royalties that they would charge for licenses to their IP. This is likely to be prohibited. Another type is going to be the joint negotiation of licenses to IP that is included in the standard. This would happen where all the members of the standard, they're going to say, for IP that is included in our standard, we're going to determine ourselves the prices, or the price of that technology cannot be above X. This may be an issue. This may be an issue because the members of the SSO would then be acting as a sort of buyer's cartel, and they might depress below an optimal level the price for IP, which might result in less competition in the future. Another type of concern will be that the SSO rules specify that members must disclose their most restrictive licensing terms, which means essentially that they will say, if my IP is involved, I will not charge more than €5 per product or something. So this would be a disclosure of maximal royalty rates, and this would happen before the standard is adopted. Again, it's if my IP is adopted, is incorporated in the standard, I will not charge more than X. So in addition to knowing that the member of the SSO has IP that covers a certain technical solution, the other members will also know that should it be included, it's not going to cost more than X. Commission considers normally this is not going to be an issue under Article 101, again, because it's just a maximum, not a minimum, not even a fixed. It's in many cases simply aspirational. And then the last one will be circumstances where the licensing terms for the SCPs themselves would limit access to the standard. That's unlikely to be the case where there's several competing standards or where there's competition between standardized and non-standardized products. But in abstract, the licensing terms that are going to be essentially the royalties that will be charged by all of the members of the SSO could in abstract limit access to the standard. As a result, this would be seen as a breach of Article 101. So now we've gone through the application of Article 101 to standardization itself, the bylaws, the governing rules, access to the standard, all of those things. Then we've gone through some of the potential restrictive effects or the concerns that relate more specifically to IP. So essentially the price under which IP will be licensed. And now we're turning quickly to Article 102. So how would Article 102 intersect with standardization and more specifically IP? Well, you would have instances where the main concern is going to be that as a result of standardization, market power will be created. That market power will be enjoyed by members of the standard setting organization who have standard essential patents. The theory is once the standard is adopted, right after the standard has been created, anyone who wants to make a product that complies with the standard, meaning he wants to implement the standard, will need access, will need a license to this IP. In many cases, in most cases, these companies that want to make these products, they will have started their investments way before the standard is actually adopted. In many cases, they will continue these investments whilst the standard is being adopted, as it is being rolled out, etc., without having, and this is all altogether common, without having first obtained all of the rights, all of the rights to all of the IP involved in the standard. So they will be locked in. Essentially, it means that parties will have already made these sunk investments. They've spent money to make things that comply with the standard, and now they will need to take some licenses, which they don't have yet, so that they can sell those products lawfully. So this is the theory. This is the notion of lock-in. And now it has been argued that there's three types of conducts by the patent owners that have been involved in standard setting that would constitute an abuse of a dominant position: patent ambush, hold up, and then recourse to injunctive relief. We've mentioned them briefly, in particular, the notion of injunctive relief, the case law on injunctive relief contained in the Huawei ZTE ruling. There's no judgments, no judicial rulings on this in the EU on this idea of patent ambush. There is nothing really on this idea of holdup, which is a failure to offer licenses on friend terms. So once the standard has been adopted, company wants to make products, goes to the member of the standard setting organization and says, how much for a license? Remember, you've committed to license on friend terms. And then the member of the SSO says, it's 100 per product. And then the implementer says 100, that's not friend, that's absurd. You're holding me up because you know that I need this license. I've already made all of these investments. This is outrageous. And the other one says, well, no, this is a friend offer. You're making products that already infringe my IP. And if you don't take a license, I'm afraid that I will have to go to court and seek an injunction preventing you from selling your infringing products. So what is this patent ambush? Again, no cases in Europe. The Commission in its horizontal cooperation guidelines indicates this as a possible effect on competition. The Commission also indicates that this will be an abuse of a dominant position. My view is that it won't be an abuse of a dominant position. It can't be an abuse of a dominant position, and for very good reason. But what's the patent ambush? Well, the patent ambush is very similar to the holdup, but essentially it consists of a company, let's see who is, here are the names that I can see. Let's see that Beatriz Navarro Santos comes to our discussions here at the BSc on our water bottle standard, and then when we're trying to determine the type of glass to be used, and we agree that it's going to be a certain type of glass made under a certain process, she sits very quietly there and doesn't say anything at all. But she knows that she has some patents that cover this, but she won't tell anyone. So we all adopt this standard, but we don't know that Beatriz has some IP on this, some patents. Okay, then we adopt the standard, people start making our water bottles, and then a couple of years later, Beatriz goes to every one of the manufacturers and says, I have these patents. You've been using my technology. Now you need to pay me. That's the notion of patent ambush. And there was a case which lasted years, very, very rich litigation in the United States and in Europe, against an American company, West Coast company, very nice people, called Rambus. And Rambus was accused of, in the context of a standard setting organization that was known as JEDEC, having done precisely what Beatriz has done here in the BSc. They met, they were discussing technologies for DRAM chips, and they said nothing. And then Samsung, Hynix, other members, they wrote into the standard this technology, and then Rambus turned around and requested that the manufacturers of the DRAM chips take a royalty-bearing license. They needed to pay them money. And they all complained. They brought court cases. The FTC went after Rambus in the United States. They brought a case against Rambus. And at the same time, the European Commission also received several complaints. The case in the FTC was well advanced, and the Commission thought, oh, we're going to do the same. And in fact, our work will be made so much easier by the fact that we can just essentially copy what the FTC has done so far, ask for the same documents and do right. So the Commission took the preliminary view that Rambus had deceived JEDEC intentionally. The members of the SSO expected that Rambus would have disclosed, right, raised their hands to say, we have patents, or, you know, we may have patents that may be essential. Then the commission said, Rambus acquired a dominant position in the technology market for DRAM chips once it began to assert those essential patents. What was the abuse? This is a sort of complicated thing. The royalties that Rambus had asked were excessive because absent this deception, the lie, right, the counterfactual, absent this deception, if they had not done it, JEDEC, the SSO, would have adopted a standard that would not have included any patents. They would have just found some other technology. Said, well, okay, if we don't want a standard that incorporates any patented technology, we wouldn't do it. So Rambus would have ended up with no IP in its standard, and it would have been no position to license. So that was the theory. Now, what was the problem here? So this is a preliminary view that was expressed in a statement of objections issued to, not a decision, a statement of objections with a press release, etc. What was the controversy? Well, the problem is that the behavior, the conduct in question was simply the deception, was not saying anything, right? So the conduct is not saying anything. But what is the dominant position here? The dominant position is a dominant position in technology for DRAM chips, which the commission asserted had only materialized once the IP had already been in the standard. So the conduct by Rambus predates the dominant position. As we know, the prohibition of Article 102 is of abuses of a dominant position, not of the acquisition of a dominant position, even by nefarious means. So this is highly unlikely to be caught by Article 102. Now, the way the commission thought that it would be able to bridge this gap would be to say, well, the royalties breach the excessive pricing prohibition because absent the deception, Rambus would have been in no position to license. But again, this wouldn't satisfy the United Brands legal test, even if one were to accept that this is anything else but a transparent attempt to circumvent the letter and the spirit of Article 102. What Rambus did may have been nasty, assuming for the sake of argument that it was. It may have been nasty, but all it did was allow them to acquire a dominant position. And competition law in Europe doesn't prohibit conduct that allows someone to acquire a dominant position. So that was the main thing. Ultimately, the commission realized that clearly they shouldn't have a leg to stand on. The case was settled through an Article 9 commitment decision with no finding of antitrust of liability, no finding of infringement. In the United States, the courts in the United States told the FTC, well, you must be out of your minds. The rules of the SSO were clear at the time. There was no expectation that parties would disclose any IP they had. So Rambus behaved in a way that cannot be considered deceptive. And in addition, in the United States, even if they had deceived, that type of deception, which simply results in an ability to extract a higher price for something, is not caught by Section 2 of the Sherman Act. You can read about more of the details of this if you want. It's a fun case. The only worrying bit is that the horizontal cooperation guidelines, as they stand, they continue to refer to the possibility of patent ambush as an abuse of a dominant position. And there's obviously no decision other than an Article 9 commitment decision that doesn't find an infringement, and which essentially that Article 9 decision was considered to have Rambus were so happy with it that people said, this is the beginning of our licensing program, because now we have the commission's imprimatur. We have the commission has found, because the commitment decision essentially says Rambus will grant licenses to its DRAM technology to any interested party and will not charge more than, I forget, $15 per chip. Well, in reality, Rambus didn't think it would be able to charge even $10 per chip. So for them, this wasn't much of a concession. And observers, Silicon Valley observers at the time said, well, this is the greatest thing to have happened to Rambus. Now they have a piece of paper that says the commission accepts that even $15 per product would be acceptable. And I think their share price shot up. But you never heard this from me. What's the other type of abuse? Well, oh my goodness, it's 5:25. Okay. Why don't we take a little break and be back at 5:30 so that I can then try to wrap things up in 45 minutes. I'll wait for people to return. Okay, doc. Let's get back to it. So the first potential abuse relating to IP in this status setting context is the first is patent ambush. The second potential abuse is failure to offer licenses on friend terms, or sometimes known as patent holdup. And what does it consist of? You know, as I said, it's a bit like the patent ambush. The only difference is the company, the member of the standard setting organization, in fact, has disclosed that it has patents that may be essential. It said, wait, you know, I may have some patents here. And then it said, but if I do, I'll license them on friend terms. And then the specifications are adopted and the standard is set. And then it goes around and asks companies to take a license to its IP. And then when it reveals these licensing terms, the companies that are implementing the products, they say, that's not friend. That's not friend. That's too high. You're taking advantage of the fact that we've made these investments already to make the products that conform with the standard. And you are abusing a dominant position. Your prices are exploitative. Is this an abuse of a dominant position? Well, the European Commission has taken the view that claiming non-friend royalties is an abuse. And we find that, although not stated as clearly in the horizontal cooperation guidelines, we find that in the first, in a non-antitrust decision, a decision by the Commission approving a merger, that's the Google Motorola acquisition. That was the first time in which the Commission expressed clearly this position. And the Commission investigated famously a company called Qualcomm for close to 5 years, dealing with a series of complaints lodged by all of the mobile communications behemoths at the time. That case was ultimately terminated without a finding of infringement, with any decision against Qualcomm, not only because Qualcomm's licensing terms were friend, but also because Qualcomm had excellent counsel. What are the legal and practical? I was involved in all of these cases, you know, in Samsung and Qualcomm, Google MMI, Motorola, pretty much all of them on one Rambus on one side, or so not always on the side of, you know, the company that ultimately prevailed. What are some of the issues, right? The first would be the question of how do one establish, you know, dominance. As we've seen, you know, ownership of IP doesn't mean that you have market power, doesn't mean that you have a dominant position. We've had this issue. Different courts have gone about it in different ways. the Commission's position, which is the position contained in, amongst others, this merger decision, but also those other decisions that we discussed briefly during the last lecture, the Samsung and the Motorola decisions. The Commission has taken the position that each essential patent, each SEP is its own market. It's essential. Anyone who needs, everyone who wants to make a product that complies with the standard must take a license to a standard essential patent. And that's also the position then that is found in the opinion delivered by Advocate General Watley in really the only judgment by the Court of Justice of the European Union in the Huawei ZTE case. That's the first issue. Now, what would be the arguments, the theories of harm can be used to justify the position that a failure to offer a license on friend terms is a potential abuse? Well, one that was tried would be something similar to Rambus, this sort of the but-for world, right? Absent this deception, what would have happened? Had the members of the standard setting organization known that this member would then, despite its promises, charge unfriend royalties, would anything have changed? Would they still have included the technology? Was the technology unavoidable? That was one of the first theories of harm that were proposed. It was based on this idea of legitimate expectations in a way. Members of the SSO and essentially anyone else would have a legitimate expectation that the company that gave the commitment to license on friend terms would abide by the commitment. Another one, which is the one which seems to be the legal standard that seems to pervade the section of the horizontal cooperation guidelines that deals with this, is simply that, well, one applies the excessive pricing prohibition. That's it, right? You check and licensing terms that are not friend are excessive. We run into these problems that now I've spoken about, but Esther has also spoken about. The excessive pricing legal standard is the one found in United Brands. You compare the price of something with the price of a rival product, or you compare the price of something with its costs. And this is obviously these benchmarks are ill-fitted for the IP world because this IP is unique, so they're really ill-adapted for all of these things. They will fail to take into account the need to remunerate innovators and inventors, including for past failed efforts. So these are the problems. And then you also have the usual other arguments as to why this should not really be an issue for competition law. Bad policy, competition agencies are not price regulators. In reality, one should continue what was hitherto this restrained, this policy of restraint, the general position that competition law should not be applied to enforce price regulation, to regulate prices. It's very difficult. A more important argument has been that most of these conflicts between owners of SEPs and implementers of the standard are essentially purely commercial disputes. The implementers want to pay less. It's absolutely normal. Competition law is a powerful tool. They've sought to enlist the help of competition law essentially to reduce prices, and this could be a main issue. Any erroneous determination by a court or by an agency of the correct price for IP would essentially result in the transfer of resources from those who develop technology to those who use technology. If you get it wrong, that's what's going to happen. Now, if you get it wrong several times, not only will you be doing this in specific cases, but you're also going to be affecting the incentives to innovate. You're reducing the return on investment for those who are involved in R&D. If this becomes more systematic, or if it becomes systematic in a certain region, let's say, for instance, the EU, we can expect less innovation. So these are sort of the policy reasons why this is a bad idea. And we now witness when I started working as a competition lawyer, and you had this type of patent infringement proceedings. Someone goes to the court and says, so-and-so is using my standard essential patents. Judge, prevent them from doing so until they agree a license on friend terms with me. You'd find most of these arguments, competition law arguments. You'd always find sort of competition law defense, but it really wasn't taken very seriously. And over the last at least decade, what you've seen is a multiplication of the cases in which the core element of the defense to the patent infringement proceedings really is the competition law aspect. And you've had many courts set friend licensing terms. The best analysis under EU competition law of, well, before I go there, courts have mostly now endorsed the position explicited by the European Commission in the guidelines that a breach of the friend promise can be an abuse of a dominant position. In other words, the excessive pricing prohibition may apply to those licensing terms, to those royalties, just as it would apply to any other price, the price for any other product. As we know, in the Latvian Collecting Societies case, we now know that essentially for a price to be discriminatory, it has to be in the Mail case, a price to be discriminatory, it has to have an impact on competition. And from the Latvian Collecting Societies case, that for a price for IP to be excessive, it should be I forget the word, that the price should be well, I forget what the term is, but that effectively it has a price that has to be charged for a long period of time. Forget what the word used by the Advocate General. It will come back to me. So we do know that, and we do know that. The best analysis of this application of Article 102 to friend licensing terms was conducted in the United Kingdom before Brexit by Lord Justice Burse in a case called Unwired Planet. Unwired Planet had SEPs, and it was pitted against several implementers of standards for mobile communications, including Samsung. The case made its way all the way to the Supreme Court in England, and the legal standard derived by Justice Burse was affirmed by the Supreme Court. Essentially, he said that licensing terms may be above friend and still not be abusive. In other words, you could find that there's been maybe a contractual breach of this friend commitment. That would not necessarily mean that the abuse of dominant abuse of dominance prohibition will have been violated. For a royalty to be excessive, for a friend rate to be excessive, it has to be very significantly above friend. It's not just a bit above friend. It has to be very much above friend. And now then the question of very much will depend on the context, on the IP in question, on comparators, on the judge, or on the adjudicator. But it has to be very significantly. So that's essentially it's this idea that it's just not because someone is going to determine that what would be fair, reasonable, and non-discriminatory would be 10, that a license specifying that the implementer will pay 11 is excessive. Not even 20, perhaps, not even 30. It has to be very much above friend. Okay, this is not bad. So, any questions? The last, you know, I will conclude with the last potential abuse, which is this recourse or resorting to injunctive relief, and that's the case that, you know, I've already spoken about, Huawei ZTE. So any questions on everything that we've dealt so far?
I have a question actually. Is there anything that we can say as some kind of rule of thumb in which area we would name a percentage and excessive pricing above friend terms would have to lie? Is it like 100% over what you, or above the area that you would still consider friend, or is it 200%? Is there any kind of rule of thumb that we could make from the case law?
I'm not sure that I got. What do you think would be considered excessive?
Yeah, excessive pricing in regard to royalties for
Well, you know, it has to be very significantly above. Now, the question of what the very significantly above means is going, as I said, to depend very much on the context, and it's going to very much also depend, in my view, on the evidence, including evidence of expectations prior to the standard being adopted, internal expectations of, because in those circumstances, essentially, in your, you know, in this factual scenario, let's say that the adjudicator has essentially used some methods to determine, and there's many methods, and the cooperation guidelines even mention several of them, the methods to determine whether a price is friend. We've gone through that. Someone has said, well, a friend price would be, let's say, between 8 and 12, an average of 10, right? We've already know that, and now the question is, the SCP owner in this case was insisting on 20, right? So twice as much. Is twice as much very much above friend? I think it will vary from case to case, and it will depend on what kind of evidence one can muster. And you can think of all types of evidence that could be useful. You know, why would it have been legitimate, for instance, to consider that twice a friend rate would not bring you necessarily into the realm of unfairness, excessive pricing, right? Why would it not been the case? It will depend case to case. What kind of evidence there was? Are there some arguments, reasonable arguments, as to why someone might have been under the misapprehension, given the finding already made that the price was 10, why would someone have been under the misapprehension that it could have been 20 or 30? Is that legitimate? I think it will vary. I would say that and it also depends on, it also very much depends also on the market, and it also depends very much, in my view, on the relevance of the IP in question and on the importance of that IP as a cost to the finished product. I think all of these considerations would be taking into account. I would expect that a price that is twice as high as friend would not be considered excessive. This is IP after all. You know, if someone says this is worth, you know, my intellectual property I think is worth 10, and then someone tells you actually we've gone through this convoluted method, we've compared, we find that it's 5, you wouldn't say, well, you know, 10 really is clearly unfair and you should have known it. That's, you know, that's my view. I think it should be very significantly above. It should be so much that the only possible conclusion is that the SCP owner could not have failed to realize that it was seeking to extort, that this was an extortion claim. But we'll have to see. You know, essentially what one reads in Unwired Planet, but also in other cases, is simply that judges are not very keen, for all the reasons that we've just discussed. They're not very keen on applying this when there's other methods. There's no reason to add the antitrust liability. They can rule on all of these cases without needing to make a finding. Then on top of it, if the SCP owner has abused a dominant position, they can just say you've breached your contractual duties. You gave a contractual commitment to license on friend terms, and you don't get an injunction. You know, go away. And they set a rate, and they say essentially they can't force a company to take that license, but they say, well, having found this, if you come before me again to seek to enforce your patents, but you've not offered a license with this royalty rate, I'm not going to give you an injunction, so you'll never be able to prevent the company that makes the product from selling it. The only, you know, you either accept my judgment and you conclude a license on those terms, or the infringer will continue to infringe. So no need to enlist competition law to resolve any such problems. And that's the reason why I think that the very much higher will have to be really a lot higher for us to see cases in which the court also finds an abuse of a dominant position. Now, agencies may have a different view, because the incentive for the agency essentially is going to be to adopt a decision that finds an infringement. They'll be, you know, unconcerned with resolving an actual problem. But I don't think, for instance, the European Commission is interested nowadays in having such cases. I think it's, you know, very much the opposite. The Commission doesn't want to entertain these claims, these complaints, arguing that so and so is offered, etc. And that's why, one of the reasons why you haven't had you know, investigations since the Qualcomm case, the original Qualcomm case, ended in 2010. These are matters which clearly are left best to the courts. The courts have struggled with this idea of applying the excessive pricing prohibition, just as they have struggled with this notion that that somehow recourse to injunctive, asking for an injunction, could also be an abuse of a dominant position.
Thank you so much.
All right. Any other questions?
Professor, I have a question. I would like to know, how the court should set the benchmark price for the court to determine whether the price is excessive or not. Because in some cases, the PIC court, they will ask the SEP holder to disclose the royalty it charged to other licensee, but the SEP holder refused to provide this information to the court. But I really don't know how the PIC court should determine the price is excessive, because they give very, very brief reasoning at this point. So I would want to know how other courts should do this.
How does the court go about determining what is friend? Well, the first thing is that every court in Europe will have its own views, right, on how. Remember, these matters are going to be dealt with first, at the national level. There's going to be an issue of what is this friend that we're talking about, right? What is it? There's the contractual friend. That's the friend commitment given to the standard setting organization. Now we also appear to hear that there's also a friend which has to do with competition law. That's the friend that is going to be relevant when you're seeking to apply the excessive pricing prohibition. If we have, if we look at the horizontal cooperation guidelines, what the Commission tells you, for instance, is, we're going to apply the United Brands test to determine whether royalties are excessive, right? So that's what the Commission's view is in the cooperation guidelines. It tells you, let's look at these cost benchmarks, let's look at these comparisons with prices charged by other SEP holders for similar IP. Now in the latest version, the one, as I told you, which hasn't been enacted yet, they also refer to a bunch of other different methods as to how one could determine the value of the IP. So we clearly have a tension here, because the courts in Europe dealing with this, and they're gonna look at this also, and primarily from this contractual perspective, saying there's a friend commitment given, let's say, to Etsy. What's the content of this friend commitment? Now let me go and see what a friend rate is, and I'll use methods that I've used in the past under my own patent law and IP system to determine whether a price for something is friend. But then you also have simultaneously this other thing which says, well, to determine whether it's excessive and an abuse of a dominant position, we're going to use this United Brands. To determine whether something is unfriend is application of United Brands. Obviously, it makes no sense. You can't reconcile them. What, for instance, the Unwired Planet Court did, Justice Burse, was say, I am familiar, and the parties have put forward these different methods for IP valuation. These two approaches, essentially, one is the top down, the other one is the bottom up. You're going to look at all of these other things, licenses for the same technology, licenses for other technology. We're going to look into an aggregate cumulative royalty, which might be a guiding principle to see whether something is a bit off. We're going to look into all of these things, and then I'm going to make a finding as to what the friend rate should be. And I don't really care about all of this excessive pricing, competition law nonsense. And I'm going to say that, well, for this to even be an issue, the rate being asked by the SEP owner would have to be so much higher, then it's unlikely to become a problem for me. And essentially, this is the kind of pragmatic solution that he adopted. He said, well, we'll have the tools. I don't want to have to deal with these claims of excessive pricing, which don't help me at all. and it would have to be very, very much higher. But we can imagine cases in which we're going to have discussions of this nature as to you, for the purposes of judging our claim and I can imagine a case in which the only claim would be excessive pricing. You need to apply the United Brands test to determine the value, and you should follow this and the other. We don't really care about methods that the courts have used in the past simply to determine friend, because this was the contractual friend. We can imagine this. But from a competition law perspective, if one is to accept that it would apply to friend licensing terms, there's a bunch of things that are there sort of discussed in the new horizontal cooperation guidelines, which are not particularly helpful. They're just references to methods to value IP, which courts in Europe have used in their work. Okay, any other questions? No, in which case I will very, very briefly. You have the slides. The slides are long. You can read the slides. The last potential abuse is this idea that by going to the court, the SEP owner goes to court. It has been unable to reach an agreement with the implementer of the standard. It has been unable to conclude a license on friend terms. Generally, negotiations will have broken down, but in some cases, the other party was not even interested in negotiations. And what you have is SEP owner has given a friend commitment, goes to court, asks the judge, please prohibit this company from making these standard compliant products because they infringe my IP and I have not been able to conclude a license agreement with them. So I'm going to assert my patents. I'm going to explain how they've been infringing all of these patents. I assert my standard essential patents and I say, this is the way in which they've been infringed. And once you, judge, have found that they effectively have been infringed, then you can enjoin them, you can prevent them from continuing to sell their products, right? So you bring patent infringement proceedings, you claim that the patents are being infringed, and then you ask for an injunction, which is the prohibition for products that infringe that IP to remain on the market, right? So far, this is not too complicated. It's a fundamental remedy, right? It's the basis of, without this, you might as well not have any IP, right? It's not like you can hide your IP in your safe. The IP is non-rivalrous in intangible, non-rivals in consumption, unless you can go to a court and say you have to order that so-and-so cease using it, you might as well not have it. So a fundamental remedy. The commission, as I've told you, has held that doing this, resorting to an injunctive relief in these circumstances, SCP holder gave a frank commitment, this could be an abuse. We had these two cases, Motorola and Samsung. Samsung, Article 9 commitment decision, and then Motorola a decision, but with no fine. Why was there no fine? The commission said, Motorola, you've infringed competition law. This is an abuse of a dominant position, but because this is a novel case and you really didn't know about this, we will not fine you. The reason they didn't know about this is because this type of thing has been ongoing for 100 years. It had never crossed anyone's mind that this might be an abuse of a dominant position. But the European Commission under Vice President Almunia finally saw the light, what had eluded so many others over a century. But that's the reason why there was no fine. It was a novel infringement, which is kind of staggering to think that we have now decided to find a novel abuse for something which is completely, run of the mill for decades and decades and decades. but so be it. That's a novel theory of harm that was advanced. I mentioned it. It goes back to exceptional circumstances, but it's no longer the exceptional circumstances of the past. It's no longer the exceptional circumstances of IMS McGill and maybe Microsoft. It's in the exceptional circumstances of the case, and then it says what these exceptional circumstances are. It's the standard setting process. It's the commitment to license on friend terms. It's prima facie abusive to seek and to enforce injunctions. So the position is, if you are a patent owner, you've given a friend commitment, it is prima facie an abuse to go to a court and ask for an injunction. That's it. Once you've done that, then the burden is on you to show that you haven't abused the dominant position. So not only novel, but also a complete reversal of what we expect to find in competition law. What was the theory? Under the threat of the injunction, the licensee will accept disadvantageous licensing terms. Essentially, you're using the threat of the injunction as a big hammer, as a sword of Damocles hanging over the head of the licensee. Once you mention this injunction, they will capitulate, sign whatever you want, give them their firstborn child. And if that's the case, you, SEP owner, you may still get out of jail free if you manage to provide an objective justification. There's 3 of them. Only the last one matters. The first one are just, absurd. This would be admissible if the licensee is unable to pay debts and it's in financial distress. In which case we don't even see the point of going after the companies that are going bankrupt in the hope of getting a steady stream of licensing revenue from them. So that one defies logic. The last one is the important. The second one is a kind of racist one. The assets of the licensee are located in jurisdictions that do not provide for means of enforcement of damages. In other words, they don't pay us. All of their assets are somewhere where there's no rule of law, and so we need to come here before a court in Europe, so that the court essentially gives us some leverage for them to pay us by preventing them from selling in Europe. And this may be justified. And maybe circumstances in which actually this happens. But if it does, it's going to concern really, it's going to concern products that are really not sold in large quantities. But the third one is then, you may still argue that the licensee is unwilling to enter into a license on friend terms. So that would be the defense. The problem then is with this notion of unwillingness. And the notion of unwillingness appeared to be that as soon as the licensee said, I'm willing, that would be it. It would no longer be an unwilling licensee. Essentially, it could simply delay negotiations. If it did anything other than say, I'm not taking a license, anything other would put it in the willing box, and therefore it would be an abuse. So, as I said, it was very controversial in large part because until then we were all under the impression that recourse to a court was a fundamental right in EU law, that the bar to find that going to court is somehow abusive. The bar was set very, very, very high. You'd have to have wholly exceptional circumstances, never met in practice. No one had ever been found to have abused a dominant position simply by going to court. In fact, the commission itself, in the only case it had dealt with, had created this test which almost ensured that there would be no cases of vexatious litigation, and it had rejected a complaint in the ITT Pro Media case. So the case was also, very, very contentious because it upended the practice in Germany. It all ended up before the court in Luxembourg. The court in Luxembourg were asked to clarify matters in a case of, patent infringement proceedings brought in Germany. While with ZTE, we've gone through the case. The Advocate General Watley delivered an opinion on that case, which is useful to read, but that opinion was essentially completely ignored by the court, and for very, very good reason. The court handed out its judgment in 2015. One of the few cases we have, one of the few rulings we have that deal with IP. And because I've already told you what it says, the court essentially creates sort of a safe harbor for the patent owners. It says that in the particular circumstances of the case where there's an essential patent, there's a friend promise, the seeking of injunctive relief will not be regarded as abusive if the dominant holder does certain things. It doesn't necessarily mean that if the dominant SEP holder does not do these things, does not comply with these conditions, it will not mean that it's abusive. It's just, safe harbor again, right? That's if they comply, if they do this, it will not be abusive. And if they don't, it may be abusive. It might be abusive. I mean, we also have to accept that if you create a safe harbor, that also means that you accept that conduct outside that safe harbor may be a problem. Otherwise, there will be no need for the safe harbor. So if it's outside these conditions, it may be a problem. It's not guaranteed. This is the test set out by the Court of Justice. As long as the SEP owner does these things, here in these different boxes, a little song and dance with during the license negotiations with the implementer, there will be no problem. And here it is in schematic form. We don't really know what happens if it doesn't really do this. And though, again, once again, in Unwired Planet, but in also cases in Germany, the position has been that, again, if it doesn't follow, if the SEP owner doesn't follow this to the letter, it does not mean necessarily that it will have committed an abuse of a dominant position. In fact, many of these things, according to the Unwired Planet judgments, many of these things have to be interpreted reasonably. And there's many details I won't bore you with, but for instance, what is the relevance of the first offer made? Does the first offer made by the SEP holder, does it need to be does it need to be on friend terms or not? Or is this just a starting point? And therefore, that if even during the proceedings, then the patent owner makes other offers which are lower, would this cure the problem or not? And the view has been, at least in the United Kingdom and also in the Netherlands, etc., that all of this this mechanism has to be interpreted reasonably, because this mechanism doesn't make much sense. And therefore, judges have to live with it, and they will have to adapt it to the needs of the case. This is a very simplistic view of what actually comes to pass in complex licensing negotiations between sophisticated parties. But there you go. And then I have a few slides at the end, which essentially summarize some of the important elements for a competitional analysis. For instance, what is the competitive harm that was found to potentially exist and that would justify applying the Article 102 prohibition? It would have been foreclosure of rivals, not exploitation of a licensee, and how that could be an issue in circumstances where the SEP owner clearly is not a rival of the company that seeks a license, because it has no incentive to exclude them. And so why would we then consider that the abuse of a dominant position prohibition should apply. They have no incentive. All they want is some money. But the court says that the risk and the reason why it has to create this safe harbor is the risk that the implementer of the standard would be excluded by an SCP owner that could reserve to itself the manufacture of the products in question. When you have someone who doesn't do it because he's not a rival, he has no interest, one may question, well, if that is the thought process, what would apply when you're not a manufacturer? There's no risk, there's no possibility of the anti-competitive effects that were examined by the court. There might be a risk of exploitation and of excessive pricing, but that's clearly not the underpinning of the judgment. And finally, but clearly a rejection of this willing licensee test put forward in the Samsung and Motorola decisions, and in the Google MMI merger decision. That's not valid. That's not good law. That should not be followed. So, as promised, only 15 minutes beyond the hour. Does anyone have any questions?
No, no question. Are you sure? Last time you see Miguel face to face before the exam? No, well, that's fine then. Thank you very much.
It's a lot, Valerie. It's always a lot to digest, and sometimes probably spoken too fast. And the subject matter, keeps growing ever bigger.
Yeah, that's true.
One of these days, it's going to be, I'm going to have to reduce, to pare it back to something, more manageable, and say, let's look at 5 cases or 5 types of abuse or something, and the remainder you can read about.
It's true. Yeah. But thank you very much for sharing your precious knowledge with us today and the last Fridays. So anyway, if there are any questions that you want to quickly discuss with Esther or Miguel, you can always send me an email. And I'm wishing you a very good long weekend to come, especially for those in Belgium. And I see you next week. Thank you very much, Miguel. And
thank you all, guys. Good luck.
Bye.
Good luck then with exams
Thank you.
and whatnot.
Yeah. Thank you.